advised.
The
All
next
right, so we
case
can
I
take him
have-
off the docket.
Thank you, Judge, is James Reese in 25 CF 2317, if we may approach.
Sure. All right, May 8th for control, 9 o'clock.
Judge, I believe that is all I have.
That's all I have for you, Ms. Mansfield.
Thank you, sir. Have a
Thank
good
you.
day.
You too. Ms. Emerson?
Morning, Your Honor. Adrian Emerson on behalf of Jackson Peret, 25 CF 1823. We have a negotiated plea. May I approach?
Yes. Thank you. All right, so I've got it as administrative probation with 10 days county jail to be served in 2-day increments. Says weekends, although state does not intend to limit the dates to Saturday and Sunday only.
Just 2-day increments, yes, sir.
Are we going to schedule what days those are? I'm not sure the jail will just take check-ins whenever they show up.
Yes, sir, and they don't, and they do need to be scheduled, and that is something that he's going to sign up with probation to do.
Administrative probation.
Administrative probation.
Is it with JCS? Or the misdemeanor county probation?
I'm not sure how that, I know how it works in misdemeanor, but I don't know how it works in felony.
Sure, we don't really see much administrative probation with DOC probation. Mr. Berry, you're kind of shaking your head. Do you agree with that?
We have people on administrative probation, but we don't do anything but run a records check. So we're not gonna be responsible for seeing if he goes to jail, and the jail guys won't Friday at 5 to Sunday at 5. I mean, they won't, it's spelled out. What it's worth.
Has anyone communicated with the jail about whether or not they're able to do this?
He's done it before, Judge, on a different case.
Okay.
That's why we specifically fashioned it this way.
What were in Okaloosa County?
Yes.
Okay. Well, what language did they use that time? Okay.
Yes, sir, I'm sorry. I know this isn't unusual.
Yeah, I understand. I just don't want to be in a situation where he either falls through the cracks or something doesn't work for him right, if this is what y'all are intending. I mean, what's the plan as far as what dates they're going to be served?
I was hoping to start as early as tomorrow. I could start maybe 2 or 3 days tomorrow, and then the weekends thereafter. I checked in at 4:30 on Fridays, and then they released me at 4:30 on Sundays.
Which is what they normally do, but to just say, I'm going to show up on a random Tuesday without any sort of...
The last
Sir?
time, I'm sorry. The last time it happened, they said I had to talk to the probation officer, and they would be able to schedule if I wanted to come in advance.
But if you're on administrative probation, the probation officer is not doing anything other than checking to make sure you did it at some point. I can put you on regular probation, and you'll have a probation officer, but, let's see here. The only other case I see in Okaloosa County for him is 2025 CF 304, and that was adjudication and time served. Well, tell me what case numbers they are then, Miss. You know, this is not usually something I look up when we're trying to figure these things out. Again, I don't want to put him in a situation where he thinks he's going to turn himself into the jail tomorrow, and they don't expect him and they don't take him. But it's been my experience that weekends are weekends. Otherwise, you know, I hate to minimize it or be flippant about it, but it's one of those, you know, they don't just take check-ins and check-outs whenever it's convenient for somebody. And I'm looking up Mr. Peret's name, and I don't see him other than the case I just mentioned in this current case.
There's some alternative spellings. I've got his other case.
Okay.
What,
Oh, I think I found it now that I took his date of birth out. Let's see. But he only served Saturdays and basically Friday through Sunday before.
Yes.
Yes, sir, that would be our intent to do that this time, I'm sorry.
So what I'm saying is the language is the same as the last time, but you didn't try to do it on a Tuesday last time, so I'm not sure if it would have worked last time.
Okay.
That, again, that's my concern. You're going to show up and they're going to say, "No, we can't take you, we'll see you on Friday." So unless someone communicates with the jail that that's a possibility, I just don't want to put it in there because then it's going to get very confusing.
Weekends would be fine.
Weekends are fine.
Okay. All right, Mr. Peret, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Jackson Peret, November 17, 1987.
Okay. I think that's one of the issues is this case has you as 1986, where your old case has 1986. I'm just telling you why I couldn't find it. You can put your hand down, Mr. Peret. All right, you're here in 25 CF 1823, where you're currently charged with felony while driving license suspended. Do you understand that?
Yes, sir.
I've got a plea and sentencing agreement. It says county court, but that's not accurate. I understand it's a misdemeanor, but it's still in circuit court. It's a lesser included offense of misdemeanor first degree drive while license suspended. Is that what you understand the charge to be reduced to? All right, and the agreement between you and the state of an adjudication of guilt says 6 months administrative probation with 10 days jail to be served on weekends, $300 fine, termination of probation upon completion of the jail sentence. It's your intent to do consecutive weekends until they're over, right?
Yes.
Okay, so starting this Friday at, is it 4:30 or 5 o'clock?
4:30.
Okay, till Sunday at 4:30, in 2-day increments until those times are done. And then you're still going to have to talk to probation. They're not going to supervise you, but I would suggest that once you finish up, you tell them that you're done so they can get the paperwork going to get you off of administrative probation, because even if you finished your jail sentence, it says termination upon completion. You just want to make sure that paperwork goes through, otherwise things could, not turn out all that great. Do you understand all that? Okay. Have you gone over this agreement with your lawyer? Did you understand and sign it? Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No.
Are you suffering from any mental health issues?
No.
Anyone force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for your plea? You understand there won't be a trial of any kind, and you're giving up your trial rights, which are listed in your agreement?
Yes, sir.
You understand you're waiving all potential defenses? And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right, and what is your plea to the misdemeanor first degree drive while license suspended? 322.34, and it's on here, Heather. Paragraph 2B1.
Yes.
No contest. I'll accept your no contest plea as freely, voluntarily, knowingly given. Can adjudicate you guilty, 6 months admin probation with 10 days county jail to be served on weekends, beginning this weekend, and consecutive weekends until you finish. Friday at 4:30 to Sunday at 4:30, $300 court costs, and then termination, probation shall terminate upon completion of the jail sentence, but again, make sure you tell probation that's been done. I will need your fingerprints, and it's a driver on the license suspended. You need to talk to probation as well before you leave, and you have 30 days to appeal. Thank you, sir.
Your Honor, we request the supervision fees be waived.
Supervision fees will be waived since it's admin.
There is a $50 admin probation fee.
Okay, there's a $50 admin fee, so you'll have to pay that as well. All right, thank you. Mr. Albrecht.
Good morning, Judge.
Morning.
Andrew Albrecht, on behalf of Sean Allen, who's present, standing to my left. Your Honor, we answered ready for trial at the last court date. We were set for docket day today. I did file a motion, as motions were required to be filed by last week.
There was a motion in limine about the testimony of the alleged victim, or
Yes.
statements of the alleged victim?
That is correct, Your Honor.
Okay.
Yes, Your Honor. We haven't had any contact with the victim or the guardian as of now. We've been trying, and Mr. Albrecht said that he had a good contact information that he was going to share with me. I do know that they've moved from Florida, but since the inception of the case, after many attempts to get in contact with them, we haven't been able to. So I would ask for a continuance this time.
Okay. Mr. Albrecht?
I would object for the purpose of maintaining Mr. Allen's right to a speedy trial.
And I looked at that this morning. Let's see. So this is an arrest from February?
That's correct, Your Honor.
So if I grant their continuance, we put it on the June docket, it'd be set for a July trial, which would still be within speedy by my calculations.
Understood.
Okay.
Yes, Your Honor, it expires on 9/15/26.
Oh, because of the information. I'm
changed the rule.
I'm still getting used to that.
Yes.
I'm looking at the arrest date as opposed to the information date.
And I think the information date was late March, March 24th, but I am still required to object if I want to maintain this right to
I agree with that, Mr. Albrecht. I'm just trying to make sure there's not going to be any issues. And again, over 20 years of practicing with one rule and they change it on us, it's sometimes hard to unprogram that. So,
Understood.
Right. So objection is noted to the motion to continue. I will grant it. However, I think it'd have to be tried in the next cycle. Otherwise, we'd have to special set it somehow. And I'm not sure how I could potentially do that. So I would expect the state to be ready to go next time.
Yes, Your Honor.
All right, we're going to set it for June 22nd at 9 o'clock for pretrial conference. Again, continuance is granted over the defense objection.
Thank you very much, Your Honor. That's all I have this morning. May
All
I be
right.
excused?
Yes, sir. Have a
Thank
good
you.
day. All right, Miss Reed, there you are.
Good morning, Judge.
Morning.
I just have one case on the court's docket. That's Coachman Siler in 25 CF 2250. It was set per day today for a written plea agreement to be filed. We did e-file that, Your Honor, but I have a written copy for the.
Sure,
the
if I
court
could
would
see
like.
that,
May I
because
approach?
I'm not quite sure if it's going to be there or not. Thank you.
We did file it late Friday afternoon. I was actually supposed to be in mediation this morning, but I found out at yesterday at 3 p.m. that the opposing party canceled, so.
Isn't that fun? All right. So it's just a lesser to paraphernalia, adjudication of guilt, time served, 270, is it 275 or 270 court costs on paraphernalia?
270.
270. Saved you $5. All right. I don't think there'd be a $100 cost of prosecution. That's in the court costs, right?
That's correct.
Yes, okay, so I'll take that off. And payable within 90 days.
Yes, Your Honor. There's no supervision or anything. It's just a plea to a lesser included
Okay.
offense of paraphernalia, possession of paraphernalia. And then 90-day to pay the cost.
All right, so I'll accept the written plea to the lesser included possession of drug paraphernalia. That's 893.147.
Yeah.
Adjudication of guilt, time served, $270, court cost to be paid within 90 days, or you can do that through a payment plan. All right, thank you.
Thank you. And that concludes my business. May I be excused?
Yes.
Okay, thank you.
Have a
nice
good day. Mr. Gilbert, come on up.
Again, Your Honor, here with Randall Tibido in 25 CF 2039 and related case of 25 CF 2290. May I approach?
Yes. Thank you. All right, so the sentence is concurrent for 2 through 6. It just says in count 2, it spells it all out, and then 3, 4, 5, and 6 says concurrent. I just want to make sure. All right, let's see. All right, Mr. Tibido, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay. And can you state your full name and date of birth, please?
Randall Shane Tibido. Randall Shane Tibido, 07/30/1986.
Okay. Mr. Thibodeau, you're here in 25 CF 2039, where you're charged with aggravated assault, deadly weapon, third-degree felony, punishable by up to 5 years in state prison. And then you've got 1, 2, 3, 4, 5 misdemeanor first-degree counts, punishable by up to a year. That's battery. Using a firearm under the influence of alcohol, improper exhibition of a firearm, 2 counts of firing a weapon within residential property. And you also have 25 CF 2290, which is a violation of a risk protection order, third-degree felony, punished by up to 5 years in state prison. Do you understand that? All right. I have a plea and sentencing agreement between you and the state that calls for you to plea to counts 2 through 6, the 5 misdemeanors I mentioned in 25 CF 2039. In return, the state would dismiss count 1 and also the entirety of the case of 25 CF 2290. In exchange would be 11 months, 29 days of probation, anger management, drug evaluation, drug and alcohol evaluation within the first 60 days, and any recommended treatment, forfeiture of the shotgun that was involved, no violent contact with Greg Dye, restitution reserved for a period of 90 days, $622 in court costs, $40 cost of supervision. Is that your understanding of the plea agreement?
Yes.
Is that the state's agreement? All right, this is a guideline sentence. All right, Mr. Thibodeau, did you have a chance to go over this plea and sentencing agreement with your lawyer?
I did.
Did you need any more time to do so?
No, sir.
Are you satisfied with your attorney's advice and representation? Did you understand and sign the agreement?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I mentioned to you?
No, sir.
All right, do you understand by entering the plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are on the first page of that agreement that you said you understood and signed? And you understand you're waiving all potential defenses? And do you understand that you're, if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and sir, what is your plea to battery using a firearm under the influence of alcohol, improper exhibition of a firearm, and 2 counts of firing a weapon inside a residential property?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on 25 CF 2039, count 1, and 25 CF 2290. All right, those counts are dismissed. And 25 CF 21, oh, hold on. Fix your case number here. 25 CF 2039, counts 2 through 6. It's going to be 11 months, 29 days of probation to run concurrently. Anger management, drug and alcohol evaluation within the first 60 days, and any recommended treatment, forfeiture of the shotgun, no violent contact with Greg Dye, 90 days reserved for restitution, $622 court costs, and $40 cost of supervision. Mr. Thibodeau, I need you to be fingerprinted. I also need you to talk to probation before you leave, and then you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence, as he scored 5.4 points. All right, thank you, Mr. Thibodeau. Step up, be fingerprinted, and then talk to probation.
That's all I have, Your Honor. Thank you.
All right, thank you, Mr. Gilbert. Have a good day. Oh, did I give away my... All right, Mr. Flowers.
Good morning, Judge.
Morning.
First matter that I'll call is 24 CF 1362. Kelvin Weise have discussed with the state with respect to some evidence that they're seeking to locate through no fault of the state attorney. And I'll let her speak to that, I think would be appropriate.
Your Honor, what happened was there were at least 10 body cam videos that haven't been available to us all this time. We just got a hold of them. We asked the sheriff's office to upload them in a different format because apparently, I guess it's because the case is from 2016, so the technology, whatever, was different. However, right now, we do
You
have
said it's from 2016?
the
I'll
case.
speak to that.
Okay.
So basically, the original body cameras of all the interviews were not available until late last week. We have now shared them with Mr. Flowers, but I haven't had the chance to even review them. And I'm not gonna,
I believe every word she said, Your Honor. If she misspeaks to the court, it'll be the first time from my perspective. I got something that was sent to my office yesterday. I didn't work yesterday. But, Your Honor, the allegations were made in 2016, and we did coordinate, the state participated in the taking of the deposition of the alleged victim, and the story couldn't have been more different than that which was reflected in the 2016 report. And so, I understand the state's just getting this.
and I guess also, Your Honor, what I can anticipate, based on a review of the body cameras with the interviews with all witnesses, it may change the state's position in the case, but I don't know that yet.
Judge, ordinarily, I take a hard line. You set this matter for trial, but I understand the predicament with respect to,
Well, let me make sure I understand. I understand the allegations from 2015, actually, according to December of 2015.
yes,
2015.
But the report was not made until 2024.
The-
Am I right with that?
Yes, what I was talking about wasn't the report, Your Honor, it's the body cameras.
So was it reported in 2015?
it was
No.
reported. And there was a warrant that sat out there for a long period of time unserved. I believe.
Yes, because Mr. Wise was incarcerated, so.
Well, no. No, that's not true.
What
He
was
lived in
it?
Alabama. Put him in jail. Judge, that's not true. He wasn't incarcerated.
Okay.
Judge, he's innocent.
Well, I
He
understand.
wasn't-
I understand it's your position,
Well,
Mr.
if you believe the
Flower.
victim- if you believe the
I'm
victim,
not-
he's innocent.
I'm just trying to figure out why things took as long as they did. Because it looks like the investigator being, sought the warrant, it says the affidavit was from 18 December 2015, and then the judge's signature on the warrant seems to be from 2019.
About right.
In fact, I can say I know it wasn't 2015 because the judge who signed it wasn't a judge in 2015. So it still was a 3-year delay, and then the warrant, I mean, at least 3.5 year delay.
Yeah, and I
I'm
agree.
just trying to piece it all together as to why there was body camera and then it wasn't done. So it is what it is. All right, so are you objecting to the continuance request?
I am.
Okay.
Well, I think I'm duty bound to do that, Judge.
All right. Anything else?
No, Your Honor.
All right. I'm going to grant the continuance requests, but I'll also entertain any motions from the defense as far as
Understand.
any other issues. Obviously, the case has been continued numerous times, including by the defense, right, Mr. Flowers?
That's correct, Your Honor. I understand the court's position.
So, obviously, speedy had been previously waived, but can reinstitute. Y'all know how that works. But I expect this to be ready on the state side, certainly by next time. But I understand if there's new evidence you haven't seen, Mr. Flowers, you may need more time for that.
Yes.
Even though this case has been around for 2 years and you're just getting discovery. Again, I'm not blaming the state, just like Mr. Flowers didn't, but I've got concerns when things like this don't get turned over to y'all in a timely fashion. It slows down the wheels of everything that we do.
We understand, Your Honor.
All right. All right. Continuance is charge of the state over defense objection. Put it for 6/22 at 9 o'clock for its next pretrial.
Thank you.
All right.
Wait for me outside. Your Honor, the next matter, Kyle Frasier, 24 CF 2179. In that case, I think Mr. Sheik now has that matter, and we are coordinating pursuant to the court's instructions, depositions this week, we hope, and so.
And that's of the victim in the case?
Yes, sir.
Okay, I just wanted to make sure.
That's where we are.
Yes, Your Honor.
Okay, is that going to be able to happen this week?
We hope, we hope so, yes.
Okay.
Yeah, the state is trying to be as open so I can
And they
get,
are.
and if I'm not able, we'll get someone in there to be
Well,
able
there's
to
no
be
criminal
there.
court tomorrow. There's no criminal court Wednesday.
Yes, Your Honor.
Yeah, we believe yes, and he has been very cooperative.
Okay. And you're brand new to the case, Mr. Sheik.
Oh, I was familiar with it because I was originally on it a long time ago,
Sure.
so I'm coming back to the case, Your Honor.
Okay. All right, so are we keeping it for Friday to see what happens?
Yes, sir.
Okay. Do we expect it'll be a trial?
As of right now, yes, Your Honor.
Okay.
Nothing to indicate otherwise.
I know we've been kind of dancing around a little bit for a trial for the last couple of cycles. I just want to get it resolved.
Yes, Your Honor. And I've
That's our best belief.
And I've spoken with the defense about it. The person who did the blood test in the case, they no longer are with an FDLE, and they're living out of Utah. But we've talked to the defense, and has no objection to the supervisor that approved it coming in to testify. We're just going to have an amended discovery that will have that individual. But I don't see that being an issue, but we have not subpoenaed that person yet. We're going to do that today, Your Honor.
All right. Well, I just noticed we've got 2 trial weeks, right? Next Monday, the 11th, and the following week, the 18th. I think I already have several that have asked for the 18th. So that kind of puts you in a tighter bind as far as getting people here. How long of a trial do y'all expect? I think you told me 2 days last time. Actually, you're one of the people who asked for the 18th.
I did ask for the 18th. I had marked it down that you told me that the 18th was.
You're right, I just
when we were going
didn't-
to do it, Your Honor.
Unfortunately, I've got too many pages of notes here, and I didn't look at both.
Perhaps if the state were more reasonable, we could cut down on some of these trials, one
Well,
wonders.
I'm sure that will happen today. Normally we get about 18 to 25 set and about 2 go, so. we'll
Yes,
see.
sir, I understand.
All right, we'll see y'all on Friday, the 8th, to make sure we're still
Very
lined
well.
up for trial. How many jurors, normal?
Normal.
I think normal's fine, Your Honor.
Yes, sir.
All right. All right,
Judge, next matter.
We'll see you
that
on
I-
Friday.
Thank you, is Michael Schneider, 25 CF 1627. Mr. Sheik, you have that case now.
Yes, I do.
Judge, I'm asking to continue it for this reason. Mr. Schneider is here. We believe that my discussions with Mr. Sheik will yield a result. There's others involved, other attorneys involved in trying to resolve this matter. I don't believe Mr. Sheik objects to a continuance, but I didn't ask him.
The state does not object, Your Honor.
It was set for plea or continue.
It was.
June 22nd at 9 o'clock for pretrial conference.
Thank you, Judge. Judge, the final matter I have is 25 CF 2427. My client's name is Nguyen, Nguyen. I think we had it plea or continuance. That's
We
what my
did.
notes reflect. I'm asking for continuance. He is here. In fact, I took the liberty of not having an interpreter here. He speaks Vietnamese and not the English language, but he understands what we're doing. It's a financial situation whereby when we get the numbers accurate, we'll be able to dispose of this case.
Okay.
And there are a lot of numbers.
I didn't even see that you're behind the monitor here, Mr. Sprouse. I couldn't see you.
Probably going to move it. No objection. Mr. Flowers is correct. This is all financial. The offer is pretty much the resolution resolves around restitution. So
Yes.
we're ironing that out.
Let's just make sure we have an interpreter for any
We will.
critical stage.
And we're still getting records from the bank.
Yes.
Because it's a like fraudulent type charge.
Okay. All right, 6:22 at 9 o'clock for Mr. Nguyen. See you back on that day.
Thank you. Judge, the final matter, Mike Gates asked me to, in the Elizabeth Harlan matter, he tells me that a deferred prosecution agreement was filed on Friday, but for me to bring that to the court's attention.
Any chance you can see that?
I can say from the state side, I signed it, and I'm pretty sure we filed it. But I did not file it personally, so I'm not, but I know I signed it.
Why don't we just set it for Friday for status?
Very well.
If you could tell Mr. Gates that, just to make sure that it gets done this week.
That's what I'll do, Your Honor.
All right,
Judge,
thank
that's
you.
all I have. Thank you, sir.
All right, have a good day. All right, Mr. Powell.
Morning, Your Honor, again.
Morning.
We were just on the Billy Wayne Purdue, Your Honor, case number 2025-1084, and I thought we were going to be able to work it out today very quickly.
Did y'all just take that over?
Yes, sir. I apologize for...
Who's that on, Miss
I
Rivers?
thought-
Is that your case? Okay.
Thought we'd work it out. You said the trial date is 18th?
The 11th or the 18th, but I don't think this case is set for trial, is it?
I could be ready on the 18th, but I
But
got
it wasn't set for trial at pretrial, is what I'm telling you.
Yeah,
Because you
okay.
weren't here. He hadn't hired you yet.
No,
Okay.
just got hired. I hate to continue it again. I know it's an older case.
Well, then he should have hired you before we had pretrial.
I understand. But I think the state and I discussed it, and he doesn't object to a continuance, but
I think that's the only option right now.
I think this was just set for status to find out if he was going to hire a lawyer like you said last Monday.
Yes.
He's now done that, so we can
Yes.
set it for the next pretrial.
yes, sir. Thank you, Your Honor.
But the case is now going to be a year old when we come back, so I expect it'll be worked out pretty quickly, one way or the other. Hopefully, so.
22nd or 24th?
22nd. 24th is for inmates, so. All right, Mr. Tony, just in time. You need more time? Okay. I heard that this morning, and I'm not sure if it was yesterday too, but.
And congratulations.
Yeah. It's the basketball issue. Mr. Tony was giving me grief when my team was not doing well, but he's also a gracious, that he'll congratulate my team when they win. All right, so we'll pass until y'all are ready. Mr. Kleins, are you ready, or do you want me to call some other cases?
A couple I can call.
Or I can call other people. Ms. Rivers or Mr. Maddox?
I can do some of my cases, Your Honor. I am working on a plea for Christopher Brand.
Do y'all have anybody who's out of custody?
I do, Your Honor.
Why don't we call them?
Yes, Your Honor. Destiny Baker?
Destiny Baker here?
She's been very good about coming to court, Your Honor. I don't
She
know
was
what
here
to do
last
to hold
week.
her up. Yes. She's
From
come
what I
every-
remember, at least.
I actually just met with her, I believe Friday, about this case, so she's been very involved. She's had several appointments with me. Okay, I will definitely reach out to her and get her here, Your Honor.
All right, let's
sure
just
I
pass
can.
it. I'll give you a chance to see if you can track her down.
Thank
Maybe
you.
there's confusion about the dates.
Yes, Your Honor. I
But-
do know that the state, it is set for trial. I do know that the state is going to be asking for a continuance, and based on my conversations with my client, the defense is going to have no objection to that.
Okay.
That is correct, Your Honor.
Well, let's,
Wait until,
Yes, of course. Stephen Ellis?
what's the reason for the continuance on Baker?
Your Honor, there are two alleged victims in this case, one of which they have differing opinions on it, on the resolution. And then one is also located in Montana, and it might be difficult for us to get them here in time for that. And so we're actually thinking about possibly bifurcating, since I believe the incidents are enough apart where that we would be able to do that, Your Honor.
And you're not objecting to the continuance?
No, Your Honor, based on conversations with my client, although I'd like to have her here to confirm that, and I'll track her down.
All right, well, it's one of the things, if we're gonna wait for her, then she has to be here, so.
Yes, Your Honor.
All right, I don't wanna feel I'm in the position of giving a capias on someone who's agreeing to a continuance, essentially, but you have to be here to do that.
Yes.
All right, just pass it, and we'll call her back up.
Thank you very much, Your
All
Honor.
right.
This is Mr. Ellis before the court in 25 CF 1728. I did file a written motion to continue this case, Your Honor. I've discussed it with Mr. Sprouse. He had no objections. I am going to file a motion to suppress in this case.
I think I signed the order this morning.
Okay.
Could be wrong about that. Let me see. I did not. All right, well, there was also an order to compel his fingerprints, right?
There was, Your Honor.
Y'all still need to do that? Want me,
I object in principle, but I understand the law is,
what's the principle?
well, my client has asked me to object, Your Honor, so I am objecting, but I understand that the court is probably going to order him to provide his fingerprints. I believe the law is pretty clear on it.
I believe it's not testimonial, and we're entitled to it, Judge. And it's laid out in the motion as far as what we need it for. It's to compare against the evidence that will be presented at trial.
All right, obviously, we're not in a time crunch now, if you're asking for a continuance, Mr. Maddox, so as far as how many days you want this to be,
In terms of
to get them done,
the fingerprints or the motion?
the fingerprints?
I don't
Has
know.
the motion been filed?
No, I have not
Okay.
filed it at this point, Your Honor.
All right,
I anticipate hopefully having that done by Monday of next week.
okay. All right. Since it's getting continued, I'm just gonna say within 30 days.
Yes, Your Honor, that works.
State's fine with that, Judge.
Yeah. I'm not gonna be back in court before that, so I don't think it changes anything.
Sheriff's office, I assume, Your Honor, to
Yes.
provide the fingerprint? Yeah, just go in the sheriff's office, let me know. If they give you any issues for whatever reason, I don't think they will, but let me know. address that.
Okay.
So it's going to be June 22nd at 1 o'clock for a pretrial conference.
Yes, Your Honor, thank you.
Anyone else out of custody? Or you have Ms. Rivers set up? Ms. Rivers, your inmates are ready.
Sorry, Your Honor, my assistant just sent me that Miss Baker has a sick child. She's working on sending over documentation for that. But we are in touch with her, so I'll call my legal assistant right now.
All right, just find out if she disagrees with the continuance. If she has no objection to it, she won't have to come in for that, obviously.
Thank you.
Your Honor, this is Blake Spieth before the court on 25 CF 889. We've reached agreement in this matter. Your Honor, he just needs an opportunity to sign it. So. 7 points. All right.
Thank you. All right, I've got, it says counts 1 and 2, it's the 10 years DOC, and then 3, 4, and 6, but at the bottom it says state Nalpros count 2, should that be 5?
And Your Honor, if we could delete that one because we changed that.
Okay, it just shows them pleading to count 2 and then dismissing count 2, so. So, what about count? Oh, there it is on counts 5 and 7, 10. Okay, gotcha.
Resistant either.
Mr. Spieth, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
David Spieth, 2506.
All right, Mr. Spieth, you're here in 25 CF 889, where you're currently charged with burglary of a structure while armed with a dangerous weapon, which is punishable by life in prison. Count 2 is aggravated assault on a law enforcement officer, second-degree felony, 15 years max. Count 3, possession of burglary tools. Count 4, possession of controlled substance. Both of those are third-degree felonies, punishable by up to 5 years in state prison each. Count 5, possession of a firearm with a removed serial number, first-degree misdemeanor, 1-year maximum. Grand theft, count 6, third-degree felony, 5-year maximum. Count 7, possession of drug paraphernalia, 1-year maximum. Do you understand your current charges?
Yes, sir.
All right, I have a plea and sentencing agreement that calls for you to plead to count 1, 3, 4, 5, 6, and 7. In return, count 1 will be 10 years in the Department of Corrections without a minimum mandatory. Counts 3, 4, and 6 will be a concurrent 5 years DOC. Counts 5 and 7, which are both misdemeanors, will just be time served. Be $967 in court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. You'll get credit for all time that you've served in this case, and then in return, the state's going to dismiss count 2. You'll be adjudicated on all counts that you enter a plea. Do you understand that, Mr. Speed?
Yes, sir.
Is that what you're wanting to do today?
Yes, sir.
All right. Have you had enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
You understand you're waiving your trial rights, which are on page 2 of that agreement that you've signed and said you understood?
Yes, sir.
Do you understand that you're waiving all potential defenses that you may have? You understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, Mr. Spieth, and what is your plea as to the burglary of a structure while armed with a dangerous weapon, possession of burglary tools, possession of a controlled substance, possession of a firearm with a removed serial number, grand theft, and possession of drug paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on count 2.
It's dismissed for plea to the other counts, Judge.
Okay. On count 1, it's going to be adjudication on all counts. On count 1, 10 years Department of Corrections with no minimum mandatory. Counts 3, 4, and 6 will be a concurrent 5 years of Department of Corrections. Count 5 and 7, credit for time served, $967 court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. You'll get credit for all time served. All monetary will go to judgment against you, Mr. Spieth. Anything that I've missed?
No, Your Honor. I have 8 counts. I have a count of resisting.
There a resisting count as well?
It should be count 3. Burglary tools is count 4.
So count 3 should be resisting an officer with violence. It's not on the plea form. It is on the information.
In the score sheet.
It is. All right, so Mr. Spieth, you understand that you'd also be entering a plea to the resisting with violence, which is a third-degree felony and punishable by up to 5 years in a state prison?
Current, all right. Yes, sir.
Okay, let's just make sure all the numbers line up at this point. Is the intent of the parties that would be another 5-year concurrent sentence?
That's correct, Judge.
Okay. So the gist of it, Mr. Spieth, is 10 years on the burglary, 5 years concurrent on each of the third-degree felonies, and credit for time served for the misdemeanors. Do you understand all that?
Yes, sir. So
Now that we've-
everything's concurrent and time served.
Yes, sir.
87.
Can you put that on the paper?
Right there.
Okay.
So it'll be count 1, 10 years DOC, counts 3, 4, 5, and 7 will be the 5 years concurrent, and then counts 6 and 8 will be credit for time served only. All right, I think we've got it all right now. All right, Mr. Spieth, I need you to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence, as he scored 44.25 months. Good luck, Mr. Spieth.
This court cost will actually go down to $615.
Court costs only $615.
Court costs went down.
Court costs went down, $350.
Your Honor, this is Ralph Thompson before the court, 25 CF 2020, 25 CF 2021, 25 CF 2309. Your Honor, he also has cases with
Mr. Notes.
We would like to put this on for Thursday. It was anticipated that it would resolve today. However, an issue had come up with points regarding drug court. So we're trying to work that out.
All right, Thursday at what time?
That's fine, I'll be here.
Issues, Mr.? You look like you want to say something, Mr. Sprouse.
No, I was trying to.
Okay, just wanted to make sure I wasn't missing anything. All right, so is Mr. Nope's understanding of the new court date?
Your Honor, I'll have to mention it to him. This is a discussion that I just had with Mr. Sprouse.
Well, I just think the issue too is, I think Mr. Nope said he was going to be in court in Fort Walton this morning and was going to be rushing up here for this. So if anyone has Mr. Nope's number, maybe tell him to slow down. Not that he's doing anything improper. Just didn't want him rushing here just to find out everyone's talking about pushing it to Thursday.
This is an easy resolution, still, Judge. I just have to go through the score sheet closely.
Okay. All right, any issues with that, Mr. Thompson?
No, sir, thank you.
All right, we'll see you back on Thursday. That's what, May 7th at 9 o'clock.
God bless you.
Hold it for Mr. Nopes.
Do you want to see Mr. Nopes this morning?
Oh, no, sir, I just
want to make sure if you need to see him, that if he gets here, that we hold you so he can talk to you.
No, I'll just come back Thursday.
All right, we'll see you on
God
Thursday.
bless.
You don't have to hold him then.
Tony? Your Honor, this is Darrell Tony before the court, 26 CF 361. We've reached an agreement in this matter.
Thank you. All right, a couple of quick questions before I go through it all. Heather, if you can give me court costs, plea as charged.
Yes.
And then it says supervised contact with his own children and their guardian.
So, Your Honor, one of the people that are listed in the case, one of the witnesses, one of the parents happens to be the mother of his child. Otherwise, he's not allowed to have contact with any of the family, other family members.
Okay.
He's going to have contact with her to be able to facilitate.
Is that going to have to be supervised? That's that's the confusing way it's kind of written. Yes?
Your Honor.
No?
Only the contact with the child has to be.
Okay, just want to make sure. All right, Mr. Tony, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please?
Errol Tony, 12384.
All right, Mr. Tony, you're here in 26 CF 361, where you're charged with 7 counts of giving obscene material to a minor, which is third-degree felony, punishable by up to 5 years in state prison, and 2 counts of lewd or lascivious exhibition, second-degree felony, punishable by up to 15 years in state prison. Do you understand your current charges?
He's got to say.
I need to be able to hear you, so if you could turn that microphone towards him, Mrs. Shivers. I have a plea and sentencing agreement between you and the state that would call for you to plea as charged. In counts 1 through 7, it would be 5 years of sex offender probation. Counts 8 and 9, 10 years of concurrent sex offender probation, so it's a total of 10 then. Be designated as a sexual offender, not have any contact with the victims or their families or any other minors. You may have supervised contact with your own children. You may have contact with the guardian of your own children. No internet access or devices capable of accessing the internet. Upon completion of a risk assessment and creation of a safety plan, those above conditions can be modified. You'll have to do sex offender counseling and an ankle monitor at $1 per day. You'll have credit for time served, waive cost of supervision, court costs. $817 in court cost. $100 cost of prosecution, that's part of the court cost, right?
Yes, sir.
Yeah, okay. So $817 court cost, $100 PD fee, and a $50 application fee. Is that your understanding of the agreement, Mr. Tony?
Yes, sir.
All right, you will be adjudicated guilty, so it's 9 felony convictions. Do you understand that?
Yes, sir.
Is that the state's agreement?
That is the state's agreement, Your
All
Honor.
right, anything the state wants to put on their record as to the plea agreement?
Your Honor, it is within the guidelines, and the primary concern was the fact that he be designated and have no contact.
And the state has complied with Marcy's law?
Yes, Your Honor.
Okay. All right, Mr. Tony, is this, have you had enough time to go over this plea and sentencing agreement with your lawyer? Is this what you want to do today? All right, I need you to speak up a little bit, Mr.
Yes,
Tony.
sir.
I mean, I can hear you, but it's very faint. All right, are you satisfied with your lawyer's representation and advice?
Yes, sir.
Did you sign the agreement? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No,
No.
sir.
Has anyone promised you anything other than the terms of the agreement I just read? You understand by entering this plea there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your trial rights, which are listed on page 2 of the agreement that you signed?
Yes, sir.
Do you understand that you're waiving all potential defenses? Do you understand that you'll be designated as a sexual offender and have to comply with those regulations and restrictions?
Yes, sir.
Do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right. And how do you plea as charged?
Contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Counts 1 through 7, 5 years sex offender probation. Counts 8 and 9 will be 10 years of concurrent sexual offender probation. You'll be designated as a sexual offender, not have any contact with the victim or their families or any other minors. You'll be allowed supervised contact with your own children. You're allowed to have contact with their guardian. Defendant, you're not going to have any internet access or be in possession of any devices that are capable of accessing the internet. Upon completion of a risk assessment and creation of a safety plan, those conditions can be modified. You to do sex offender counseling, an ankle monitor at $1 per day, credit for time served, waive cost of supervision, $817 court costs, $100 PD fee, and a $50 application fee, and then you will be adjudicated on all counts. This is a guideline sentence, as you did not score prison with 40.90 points. Anything that I've missed? Mr. Tony, I need you to speak with probation. I also need you to then be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
You want to talk to Mr. Barry?
And Your Honor, he will remain incarcerated until GPS is attached.
Yes. GPS will have to be attached before he's released.
Your Honor, this is Lonnie Ward before the court on 24 CF 2269. We've reached, if I may approach.
Yes. Ms. Rivers, you signed for the state attorney. They didn't sign at all.
Person to be charged, though.
Say again?
Person to be charged.
I understand, but Ms. Rivers, you're signing this, a certificate of the defendant's attorney that you've gone over all these things with him? Okay. All right, Mr. Ward, can you raise your right hand? Did you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, and can you state your full name and date of birth, please?
Henry Ward, February 15, 1966.
Do we have guidelines for Mr. Ward? All right, could you pass those up, please? All right, Mr. Ward, you're here in 24 CF 2269 on a violation of probation. Do you understand that? I have a plea agreement here between you and the state that calls for you to admit your violation of probation. Your probation will be revoked and terminated. You'll serve 11 months, 29 days in the Okaloosa County Jail, $100 cost of prosecution, $100 PD fee, $50 application fee, and credit for time served. It'll be an adjudication of guilt. Do you understand that?
Yes, sir.
Have you gone over this plea form with your attorney?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your attorney's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Nothing, sir.
Say again?
Sober. No, sir.
No, sir. I heard sir, I didn't hear the yes or the no, so that was, let's see. Are you currently suffering from any mental health?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering an admission, there won't be an evidentiary hearing where the state would have to prove how you violated your probation?
Yes, sir.
You understand you're waiving any potential defenses?
Yes, sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that?
You.
I'll accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty, revoke, and terminate your probation. Sentence you to 11 months, 29 days in the Okaloosa County Jail, $100 cost of prosecution, $100 PD fee, $50 application fee. Give you credit for time served. All outstanding financials will go to judgment against you, Mr. Ward. This is a guideline sentence as you scored 40, well, it isn't a guideline sentence. Reason for the departure?
Unforced negotiated plea.
Okay. You scored 16 months. Mr. Ward, do you understand that?
Yes, sir.
And the reason that you're not getting 16 months is because you made the agreement. Do you understand that?
Yes, sir.
All right, Mr. Ward, you have 30 days to appeal the judgment and sentence of the court. I believe we already have his fingerprints. All right, good luck to you, Mr. Ward.
Thank you, sir. Thank you.
Your Honor, I actually do have one out of custody, Gary Wright, 26 CF 388. He is present and approaching, Your Honor, and we do want to leave him on the trial docket.
Leave him on the trial docket? All right. How long of a trial do you all expect?
Today,
1 day. Who's the prosecutor on right?
Ms. Flowers.
Yes, Your Honor, I reviewed, I did get some information. It appears that neither victim in the case wants to participate, so the state would announce no process.
All right, case is dismissed, Mr. Wright.
Thank you, guys.
Anyone else that you're ready on? Mr. Powell, are you ready? Morning.
Powell, I'm Jonathan O'Shea.
Is he in custody or?
He's out of custody, Judge.
Okay, where's he at?
Judge, Mr. O'Shea has some pretty substantial health issues. I was asking to put it on Thursday. We have a resolution. He just couldn't get here today. This is when we had the GPS monitor removed by stipulation because he had to have an MRI in the hospital.
Okay.
A lot of health issues. He was
Thursday? Not Friday?
Or whatever the next immediate court date.
Well, I have one Thursday, I have one Friday. Thursday's a miscellaneous day, and there's a lot more going on than there will be on Friday.
Friday would be fine.
Okay. Does it work for Friday for the state? It was listed as plea or continue, right?
O'Shea.
You said it could not on Friday?
I'm sorry.
Can we just continue, or could we?
Thursday?
I would like to not have so many cases on Friday.
Thursday?
Either way.
I'll be here both days.
Do you think you can get the PTI?
Yeah, I'm doing it right now.
Okay.
All right, Thursday, May 7th, 9 o'clock.
Thank you. You said you have a busy docket that morning?
Most of the days are, yeah.
Okay.
Friday typically is unless we have a bunch of motions for trials, but I don't know that yet, so.
I do have Judge Love that morning, so I just wanted to make sure I'd be okay bouncing between there.
Yeah, we'll be here all day.
Okay.
I would expect. Although last Thursday, our miscellaneous date in the morning was actually done at like 11 o'clock. So.
I'll get it figured out.
Just get us a message if you think you're going to be terribly late, but otherwise we'll take you when you get here, Mr. Powell.
Thank you, Judge. Have a good day.
You too. Mr. Garrett.
Morning, Ron.
Morning.
Your Honor, Chris Garrett on behalf of Jason Brown, 25 CF 722. This was set for status about a deposition. We did get that scheduled for May 19th. We'd ask for a continuance.
What was the date of it?
May 19th.
May 19th. All right, any objections?
No objections from the state, Your Honor.
Okay, so let's go June 22nd at 9 a.m. for your pretrial conference.
Thank you, Your Honor. And then I had one of the client who might have already fallen off the docket, Timothy Scarborough, 25 CF 2295.
That was one that was going to transfer to misdemeanor?
Yes, Your Honor.
Does that happen, State?
Ms. Flowers.
Timothy Scarborough.
Scarborough.
Yes, Mr. Scarborough's case is actually going to need to be put on, it should have been sent down to misdemeanor court.
I just don't see anything in the court file yet. That was my note from last week, but I don't know if it's been filed, I just can't see it yet, or what.
Yeah.
I can, that is the state's intention. We'll just have to get the paperwork done.
All right. Why don't we just keep it on Thursday for status? Well, obviously, once it gets transferred, it'll fall off this docket and you won't have to be here.
5/7 for status at 9 AM?
Yes.
I believe that's all I have, Your Honor.
All right, thank you, Mr. Guerin.
Thank you, Your Honor. Have a good day.
You too. Mr. Rare?
Morning, Your Honor.
Morning.
For the record, David Rare, Judge. The first I've got is Stephen Gardinier. Speaking with the state, I believe we're going to have a resolution on that in the near future. If we can bump it out to the pretrial, that might be able to fall off before we even get there.
Okay. June 22nd, 9 o'clock for pretrial. It was listed as plea or continue.
The next judge is probably still on the docket, Marcus Hamilton. I believe a dismissal has been filed in that case.
Was filed yesterday, Your Honor.
Let's see. Filed yesterday, and I can see it. All right, so Marcus Alexander Merle Hamilton, 26 CF 326, has been dismissed, no prosecution by the state.
And then last I should have on the docket, Your Honor, is Sigrid Wasden, 25 CF 1717. We've had some conversations with the state. We're not quite there yet. We're going to go ahead and move forward with setting depositions. I believe we're in the process of scheduling dates. And so I'd ask if we can set that for the pretrial on June 22nd.
Okay. She's present June 22nd, 9 a.m. for pretrial conference. We'll see you back on that date.
That's all I've, Judge.
All right, thank you, Mr. Rare. Mr. Maddox, I guess yours are lined up?
Yes, Your Honor. Your Honor, this is Mr. Brand. Before the court in 25 CF 848. Your Honor, we do have a resolution in this case. I just need to finish writing it up.
All right. We'll call you back, Mr. Brand.
Brown?
Your Honor, this is Mr. Brown before the court in 25 CF 1828. Did the state get a chance to file an amended information in this case?
No, not yet.
Okay. Are you able to do it before the end of today, do you think?
No, because,
It's lesser.
no, it's not lesser yet. I can try before the
Okay.
end of the day.
So, Your Honor, we have an agreed-upon resolution in this case. He would be released. It'd be for 3 years of probation, pleading to a different charge of child abuse. So the state would need to file an amended information in this case. If the court is comfortable allowing the state to file it after the plea is accepted, then we can do that, but if not, then...
I'd rather not.
Okay.
Just the way things drag through the portal and all that, I'd rather everything just be filed.
Okay.
I'll get it done, Your Honor, before the end of the day.
Okay.
Right now.
Do we want to bring them back on Thursday?
Yes, Your Honor. So you get out on Thursday.
All right, so are we taking this one off the trial docket then?
I don't believe, I think it was plea or continuance, Your Honor.
Wait, I'm sorry, I flipped back to Mr. Brand, I'm sorry.
Yeah,
This is
was
Mr. Brown.
yeah,
You're
yes,
right.
sir.
Yeah, my page flipped back over, sorry.
Yes, Your Honor. So we'll have it hashed out on Thursday.
All right, we'll put them on May 7th, 9 o'clock for plea.
All right. We'll get you out, all right. Honor, this is Mr. Collins before the court in 26 CF 69. It was set for plea or continuance today, Your Honor. I am asking for a continuance in this case.
Okay. I think it's only the first or second time up, right?
Yes, Your Honor. I believe it's the first.
State?
No objection from the state. And did you want to mention about the bond?
No, I'll follow a bond motion and I'll get with you on it.
Okay, all
There's
right.
some things we'd have to work out.
Yep.
All right, June 22nd, 9 o'clock. Oh, and for your reference, Mr. Mattis, I have Mr. Dempsey is on Zoom, whenever you're ready for him.
Thank you, Your Honor. Did you mean the 24th, Your Honor?
I'm sorry, you're right, June 24th.
Okay. All right, I'll come see you. Okay, I'm going to get a bond.
It's very low.
This is Ms. Cox, Your Honor. Before the court in 20 CF 3038, we do have a resolution in this matter. May I approach, Your Honor?
Yes. All right, Ms. Cox, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right, can you state your full name and date of birth, please?
Chloe Kiana Cox, 11/22/2002.
All right, Ms. Cox, you're here in 2020 CF 3038 for a violation of probation. I've been handed a plea agreement that calls for you to admit your violation, revoke and terminate your probation, 11 months, 29 days in the Okaloosa County Jail, comply with the ECLC program, $100 VOP fee, $150 cost of defense. Those costs will go to judgment and be an adjudication of guilt. All prior credit would be waived prior to April 30th of 2026. Do you understand that?
Yes, sir.
Is that the agreement that you've made?
Yes, sir.
You can put your hand down. Is that the state's agreement?
That is, Judge.
All right, that seems to be a hefty downward departure.
It is, she was principal in the underlying case that went into,
How much time has she previously served?
I know she didn't go to prison.
Okay. She scores 70 months.
Right.
Yes, Your Honor.
Anything else the state wants to put on the record as to the plea agreement?
Yes, if the court were to see the initial report on this case, you would, it would shed light on the state's offer and agreement.
Okay. So that report's in the court file?
Yes, sir. Yes, Your Honor.
All right, Ms. Cox, did you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've read? Understand by entering an admission to your violation of probation, there won't be a hearing where the state would have to prove how you violated. You understand you're waiving all potential defenses. And do you understand if you're not a U.S. citizen, you could be deported or excluded from the country based on this? All right, and what is your plea to the violation of probation? Are you admitting or denying? I'll accept your admission as freely, voluntarily, knowingly given, revoke and terminate your probation. You're to serve 11 months, 29 days, Okaloosa County Jail, waiving your credit prior to April 30th of 2026. Comply with the Emerald Coast Life Center program, $100 VOP fee, $150 cost of defense. Those costs will go to judgment. This is an adjudication of guilt. Did you previously have her fingerprints? No. All right, you'll need to be fingerprinted. You understand this is a felony conviction. All right. All right, and the reason for the downward departures?
It's a negotiated plea, Judge.
Okay. Negotiated plea is the reason for the downward departure. All right, Ms. Cox? Yes.
Waiving credit from when?
Waiving credit before April 30th of 2026. So she can have the year to do the ECLC program.
Yes, Your Honor.
I need to fingerprint, you have 30 days to appeal, Ms. Cox.
This is Mr. Curtis before the court in 26 CF 22, Your Honor. We're here for competency proceeding today. The state and I were unable to come to a stipulation on the report. I do believe the court has previously reviewed it. Your Honor, I don't have, what we're trying to figure out here, and the court could perhaps direct us, is whether to just go ahead and seek the second evaluation or do this additional testing that Dr. Zeman has recommended. I'm fine doing either. Given that we weren't able to reach a stipulation on it, I'll kind of go with the court's preference on this one or the state's recommendation on it.
Ms. Leone, what's the state's position?
The state's concern is the fact that, and I'm not sure if the court has had the chance to review the report yet.
I think I reviewed it last week, but now when I try to pull it open, it's completely redacted, so I can't even see
I have
it
a
now.
copy, Your Honor.
So the problem that the state has with the report is that it's based only on what the defendant has told Dr. Zeman, and Dr. Zeman himself states that a better evaluation could be accomplished by administering additional tests to the defendant. So I don't know if Dr. Zeman is going to go ahead and perform those tests, or we should seek a second evaluation.
And defense is amendable to doing either one. Again, I would seek some guidance from the court because Ms. Leone and I had discussed we really don't want to waste resources if it's, if we don't have to. So I could do another internal evaluation requesting this additional testing, or we could go ahead and get a second report and see if both of them agree he's incompetent and do additional testing if we need to after that.
Well, part of the problem is he also doesn't have, Dr. Zeman wasn't given access to any school records or anything like that.
Yes, Your Honor, that's correct. And in some situations, I could appoint, the APD who may have better access or better ability to get those records, but Dr. Zeman doesn't necessarily recommend one or the other. But if we did get a second report, we could certainly at least determine whether we believe he's competent or not to proceed and then go from there, doing additional testing if need be.
Does the state have a preference on how we go about this? Just because this is an internal evaluation that was done by the PD's office.
Yes, Your Honor.
So do you want a second one appointed since you don't agree with it? I'm not saying you disagree with it, but you don't agree with that it needs more to it.
Yes, Your Honor. again, as Mr. Maddox explained, we're trying to save time and resources. Again, if Dr. Zeman was going to go ahead and perform additional tests and come up with a better evaluation, at least better founded evaluation.
My concern is if he does that and you don't agree.
We still don't agree.
Correct. That was something we had discussed as well. So here's what I would also put forth, Your Honor. Dr. Zeman right now has a faster turnaround. The additional testing would most likely be quicker coming from him. If the state is then satisfied with that, then we could stipulate to the report, and that would save us some time. Dr. McDonald is more busy than Dr. Zeman, at least at the moment, so her reports are running quite a bit of time to complete.
Why don't we have Dr. Zeman do the further testing then and see where we come up?
That would be fine.
Okay, let me give you that back, Mr. Maddox.
I will do so.
All right, you want to put them on June 22nd?
Yes, Your Honor, the next.
I'm sorry, June 24th. June 24th at 9 a.m.
Yes, Your Honor. I'll get that testing
We get that done
request in
quickly.
today.
Okay.
Yeah, yes, sir. We're gonna have a resolution, Your Honor, I just need to write it up.
All right, we'll pass Mr. Day until we can bring him back up.
It'll be the 11/29, Cody.
Hold on a second.
Your Honor, Mr. Demon's case is set for trial in 25 CF 1343. We have reached a resolution in this matter.
Okay.
You signed it, yep. Need your signature, Mr. Strauss. Thank you.
All right, Mr. Denman, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Delman Brian Denman Jr., 6/26/1986.
All right, Mr. Denman, you're here in 25 CF 1343, charged with flee or attempt to elude law enforcement, second-degree felony, punishable by up to 15 years in state prison, and then 4 separate second-degree misdemeanors punishable by 60 days in county jail each. Failure to have insurance, no vehicle registration, attaching tag mounted sign, and driving while license suspended. Do you understand your current charges? I have a plea and sentencing agreement that would call for you to plea as charged, be credit for time served, adjudication of guilt, so that's a felony conviction. Court costs?
Had 548, that's what I got, okay.
Oh, I'm sorry, you've handwritten it down
I
here.
in there, yes, Your Honor.
Is that accurate?
Yes, Yes.
Okay, $548 in court costs. Thank you, Mr. Maddox. I just saw court costs here, and then you wrote it out on the bottom.
Yes, Your Honor.
$150 cost of defense, your costs will go to judgment. Is that the state's agreement as well?
Yes, Your Honor.
This is a downward departure.
That's based on a legitimate, uncoerced plea.
All right, anything else the state wants to put on the record as far as that?
No, Your Honor.
Okay. All right, Mr. Denman, have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Anybody force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything other than the terms of the agreement I just read? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
You understand by entering this plea, there won't be a trial of any kind?
Sir.
And you're giving up your trial rights are on page 2 of the agreement you've stated that you've understood and signed? And you understand you're waiving any potential defenses that you may have?
Sir.
And you understand if you're not a U.S. citizen, this could lead to your deportation? All right, and what is your plea as charged?
No contest.
No exception, no contest plea is freely, voluntarily, knowingly given. Adjudicate you guilty on all counts. Credit for time served, $548 court costs, $150 cost of defense. Those will go to judgment against you, Mr. Denman. I do need your fingerprints. You have 30 days to appeal the judgment and sentence of the court. You did score 21.3 months in state prison, but it's a downward departure based on your agreement with the state. All right, step up and be fingerprinted. Is there another case? What about the other case?
I'd ask to continue that case, Your Honor.
Okay.
That's his first, I think it's the first time up in that.
It is the first time up. All right, so 26 CF 288 will be continued to, is he in custody on that case?
Yes, Your Honor.
All right, June 24th at 9 o'clock.
Mr. Eastley, Your Honor, we have a resolution in this matter. May I approach?
Yes. All right, Mr. Eastley, can you raise your right hand? Do you swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Brandon Lee Eastley, 4/20/1993.
And Mr. Eastley, you're here in 26 CF 50 on a violation of probation for 2 misdemeanors, punishable by up to a year in county jail each. Do you understand that?
Yes, sir.
All right. And let's see, I have a plea agreement between you and the state calls for you to admit your violation, revoke and terminate your probation, 120 days, Okaloosa County Jail with credit for all time served, be an adjudication of guilt, $100 VOP fee, $100 cost of defense. Your incarceration is concurrent between the 2 counts. Do you understand that?
Yes, sir.
Have you had enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir. For sure.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues?
None.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
I'm sorry, what was that?
No, sir.
That's what I thought you said, but I just wanted to make sure it was kind of muffled. All right, and has anyone promised you anything other than the terms of the agreement?
No, sir.
And do you understand by entering this plea, there won't be a violation of probation evidentiary hearing where the state would have to prove how you violated?
Right. Yes, sir.
You understand that?
Yes, sir.
Okay. And do you understand you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the violation of probation? Are you admitting or denying that?
I'm admitting.
I'll accept your admission as freely, voluntarily, knowingly given, revoke and terminate your probation, sentence you to 120 days Okaloosa County Jail, credit for all time served, $100 VOP fee, $100 cost of defense. That incarceration is concurrent between the two counts. I don't think I need his fingerprints, but you do have 30 days to appeal the judgment and sentence of the court.
And outstanding monies to collections.
Outstanding monies to collections. Thank you.
Mr. Enzenbacher. Your Honor, this is Mr. Enzenbacher before the court in 23 CF 1532. Set plea or continuance today. I am asking for a continuance.
Without objection.
June 24th, 9 o'clock.
Thank you, Your Honor.
Mr. Maddox, what are we doing?
We're going to have a resolution in this case.
You gonna bring it back?
Yes, Your Honor, I'm going to
All
write it
right.
up.
We'll bring you back, Mr. Fiducia.
Apologies.
It's okay, I just want to make sure we're getting somewhere.
Your Honor, I'm going to ask to continue Ms. Gary's case to the next pretrial conference.
Date?
No objections from the state, Your Honor.
June 24th, 9 o'clock. This is the first time up for Ms. Gary. Is that everyone you had, Mr. Maddox? Oh, I've got Dempsey on Zoom. All right, can you hear me, Mr. Dempsey?
Yes, sir.
Okay. All right, what are we doing with Mr. Dempsey today?
We have a resolution, Your Honor. Going to be the plea to the misdemeanor assault on law enforcement as discussed, Your Honor. I did send over Mr. Dempsey the plea agreement, reviewed it with him. He signed it. I've signed it today. The state is executing it now. It will be credit for time served, Your Honor, if I may approach.
Yes. Adjudication again. Okay. All right, Mr. Dempsey, can you see me okay?
Yes, sir.
Raise your right hand, and do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Ernest Dempsey, 9393.
Okay, and Mr. Dempsey, you're here on 25 CF 1986, where you're currently charged with resisting an officer with violence, third-degree felony, 5 years maximum, and also assault on a law enforcement officer, which is a first-degree felony and punishable of up to a year in county jail. Do you understand that?
Yes, sir.
plea agreement here that calls for you to plead to count 2 for an adjudication of guilt, credit for time served, 622 court costs, $100 cost of defense, and 90 days to pay those costs. And then in return, the state would dismiss count 1. Correct?
That is correct, Your Honor.
All right. Is that what you want to do here today?
Yes, sir.
Did you go over this form with your lawyer?
Yes.
Did you understand and sign it?
Yes, sir.
All right. Are you satisfied with your... I don't think she's hearing him. Can you not hear him on the Zoom? Okay, I'll see what I can do. Thanks. Let's go ahead and do this just to make sure. All right. Mr. Dempsey, something probably popped up on your screen. Just hit OK to that. I'm just going to record the Zoom to make sure that we're hearing your voice on the record, even if it's not in the courtroom. But just if you could, try to speak up for us. All right. Are you satisfied with your attorney's advice and representation?
Yes, sir.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement I've read?
No.
Do you understand you're waiving all potential defenses?
Yes, sir.
Do you understand you're giving up your right to a trial, all your trial rights that are on page 2 of that agreement that you reviewed and signed?
Yes.
And do you understand if you're not a U.S. citizen, you could be deported or excluded from the country based on this?
Yes, sir.
All right. And what is your plea to the assault on law enforcement officer, first degree misdemeanor?
No contest, sir.
Are you pleading no contest as indicated by your form?
Yes, sir.
Okay, so what is your plea?
No contest.
There we go. All right, I'm accepting no contest plea is freely voluntary, knowingly given. State have an announcement on count 1.
State will dismiss count 1, Your Honor.
All right, count 1 is dismissed. Adjudication of guilt, credit for time served, 622 court costs, $100 cost of defense. Mr. Dempsey, I'll give you 90 days to pay those costs. Make sure you report to the clerk's office to do that or contact them. You do have 30 days to appeal the judgment and sentence of the court.
Okay.
All right, thank you, Mr. Dempsey.
Thank you.
Have a good day.
You too.
I do apologize, Your Honor. I missed 3 out of custodies from this morning. Do you want me to call them now or call them towards the end here?
Are they ready? Do you know who they are? Do you know who they are?
I have Dalton Carpenter, Sean Cobb, and Cecil Espinino.
Do y'all have them pulled up? Or? Do y'all have them?
They're out.
Oh, they're out of custody. I thought you said in custody. You want to call them?
Oh, yes, Your Honor. I'm sorry, I thought you were still looking over. Dalton Carpenter. President approaching, Your Honor. We will have a resolution in this matter. I may approach.
All right, Mr. Carpenter, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Make sure you speak into that microphone.
Yes, sir.
All right, can you state your full name and date of birth, please?
Dalton Blake Carpenter, 7207.
All right, Mr. Carpenter, you're here on 25 CF 1821, charged with fleeing or attempting to elude law enforcement, 15-year maximum and a second-degree felony, also no vehicle registration and driving without a valid driver's license. Those are both second-degree misdemeanors and punishable by up to 60 days in county jail. You understand your current charges?
Yes, sir.
All right, you can put your hand down, Mr. Carpenter. I have a plea and sentencing agreement that would have you plea to a lesser included offense of unenhanced fleeing or attempting to elude, Florida Statute 316.1935, paragraph 1, and then as charged in counts 2 and 3, it'd be an adjudication of guilt. On the felony, it would be 2 years of probation, $150 cost of defense, $548 in court costs. Counts 2 and 3 would just time served and adjudication of guilt. Do you understand that?
Sir?
Do you understand that's a felony conviction for you?
Yes, sir.
And how old are you?
18.
All right. Mr. Carpenter, have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read to you?
No, sir.
You understand by entering a plea there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your trial rights, which are listed on page 2 of the agreement that you stated you understood and signed?
Yes, sir.
And you understand you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right. And what is your plea to the third-degree felony fleeing or attempting to elude, no vehicle registration, and driving without a valid driver's license?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. On count 1, adjudication of guilt, 2 years of probation, $150 cost of defense, $548 court costs. Counts 2 and 3, adjudication of guilt and credit for time served. This is a guideline sentence as you scored 4.4 points. I do need you to speak with probation, Mr. Carpenter, but first if you could come up and be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. Yes, probation fees waived. Thank you, Mr. Berry.
Sorry, Your Honor, if I missed that in the plea.
No, it's okay. I forgot to.
Sean Cobb? John Cobb? I don't have any information on him at the moment, Your Honor, but I'll see what the situation is. We did have a resolution for him. Cecil Espinino?
Just a second. What we do? All right, well, from Mr. Cobb, was he here last week?
He was.
All right, Mr. Cobb was here in 25 CF 2101 last week with you, Mr. Maddox, on April 27th. He was given today's court date at 9 a.m., which is now approximately 10:56. If he shows up, we'll withdraw it, but otherwise it's a KPS with no bond.
Yes, Your Honor.
All right. Who do we have?
This is Mr. Cecil Espinino, Your Honor, 26 CF 172. Did you have the official paperwork for that, Mr. Chief? I know you said there was an offer, but.
Yeah, we have not sent the official one. If he wants to sign it today, we can get it.
Yeah, he's gonna sign it.
This is a PTI?
Yes, Your Honor, it's gonna be a PTI.
With plea? Or
I
without?
believe it was without.
Without
a plea. So just a regular PTI.
Just get it filed, we'll take it off the docket.
Okay. Just come to my office. Time today to come to my office? Okay, could you come this afternoon?
Well, if he's not getting it done while he's here, then I have to give him another court date.
Yes, Your Honor, let's do that.
What date would you like?
I could put him on the 7th just to knock it off.
If y'all feel you can get it done, that's
We can
fine.
get it done by the 7th. Okay.
All right, May 7th at 9 o'clock, we'll see you back that date, Mr. Espino, unless you can give the paperwork back and then get it filed.
All right, thank you, Your Honor.
All right, thank you.
Yep. Okay.
That everything, Mr. Maddox?
Yes, Your Honor, then Ms. Baker did send me some information. I'm going to review that right now.
Is she objecting to the continuance?
No.
All right, so let's go back to that one. That was Destiny Baker, 25 CF 1727, state asked for a continuance, and Mr. Maddox, you're now telling the court your client has no objection to that continuance?
That's correct, Your Honor.
All right. It's going to go to 6/22 at 1 o'clock.
Thank you, Your Honor.
All right, thank you. All right, can I take one before you, Mr. Kleins? Ms. Randi? Ms. Randi, you're here in 24 CF 162. I know last time we went through the Peret hearing, but then you also wanted standby counsel. I appointed Mr. Nopes. Obviously, he didn't know about that. He was supposed to be here for another case, but that got resolved, or at least got pushed till Thursday. But I don't have anything else as far as notes as to what we were going to do with your case today.
I do would like to request a joint trial with my husband.
Okay, well, he's already set for trial.
Right, so I'm requesting to be put on for the 18th, or for the 20th, the week of the 18th.
Are you ready for trial for this period without having talked to your standby counsel?
I believe so, yes.
All right, state?
I have no objection, I'm ready for trial on both.
Okay, you want to do them together?
Yes, sir.
Okay. All right. Raise your right hand, Ms. Randi, because there's one more thing we haven't talked about.
Okay,
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
yes, sir.
I think one of the other issues is you would want to waive your right to a jury trial, right?
Yes, that's correct.
As your husband has.
Yes, correct.
And now you're trying to join the cases together for the purpose of a trial.
Yes, sir.
Do you understand that you have a constitutional right to a jury trial in this case?
Yes, sir.
And I think we talked about this a little bit last week, but do you understand that if we go forward with the bench trial, and if I were to find that that you were guilty of what the state's charged you with, you don't get another chance and then ask for a jury trial? Do you understand that?
Yes, sir.
And I think I brought this up last week because in some states you actually do, including, I believe, Alabama, you can do that, but it might only be on misdemeanors. I'm not quite sure because I'm not licensed in Alabama, but I just wanted to make sure that distinction is made. Do you want to talk with your standby counsel before you do that?
No, sir.
Okay, because my concern is your standby counsel was just appointed last week and might not even know that he's been appointed to your case as standby counsel. So to set it for trial without him present makes it kind of difficult.
I understand.
Okay.
The way that I see it is...
Hold on a second, I gotta ask some other questions. Ms. Leone, is the state waiving its right to a jury trial?
Yes.
Okay.
My husband and I, we've known each other since 2010. We've been married since 2012, and we've had our children together, all of them. And this is for them. Every decision we make is in the best interest of our children.
Okay.
They rely on us.
I'm not sure what that has to do with your right to a jury trial.
We're deeply committed to our children, to their stability, to their daily care, to their well-being. And when I read the statute, the Florida statute 827.03, I am no abusive parent and I am no neglectful parent.
Okay.
And I know that down to the core, and I know my husband is not. So I feel comfortable going to a bench trial, presenting the facts before you, Your Honor, because you know the laws, and you can read everything and see everything. You have years of experience that you will make the lawful, correct decision.
Okay. Now, just to get out in front of it, if someone talks to Mr. Nopes and finds out he can't be available for the dates we've already set for that trial, which I believe is May 20th and 21st, do we think it's going to last 2 days as a bench trial?
I don't think so.
So most likely May 20th, although we're going to have another court date on Friday to discuss those things. That if he can't be present, Mr. Nopes, your standby counsel, you may have to make a decision as to what you want to do in that circumstance. But what I want to make sure you understand completely is your husband will not be representing you. You will not be representing him. You're not going to be making arguments on behalf of each other. Because to have someone who's not licensed to practice law represent someone else would be unlicensed practice of law. Do you understand that?
Yes.
And we'll discuss it more with Mr. Randi and probably you on Friday. So we can mark it down for that trial period and come back on May 20th as a bench trial, since everyone has waived their right previously. I think that was the one thing we were remaining as miscellaneous, since it's your case and you weren't here last week, that I didn't want to take anyone else's word for that, since it's your case, as to whether or not you want to waive the right to a speedy trial on behalf of the state.
Appreciate it, Your Honor, yes.
Okay.
The only, I was just gonna mention though, should also Mr. Rolandi agree to both cases be tried the same?
Well, he's not here, and we set him for Friday, so we'll discuss it more on Friday.
That's
But, it's unfortunately, we're kind of piecemealing these things more than I would like, as they're quickly coming to a head after 2.5 years.
Right.
I've only had the case for 4 months, but I want to make sure that we're getting a resolution as soon as possible. But I also want to make sure I'm taking into account your constitutional rights, jury trial, to represent yourself, to have counsel. And we just went through a pretty thorough Peret hearing, asking you all those questions last week. Have you changed your mind at all, Ms. Rolandi, as far as wanting to be represented?
No, sir.
Okay. All right, well then we'll see you back on Friday, 9 o'clock. And we'll see if we can't get everything figured out as quickly as possible then. But does anyone have Mr. Nope's contact information so she can reach out to him?
Yeah, I can share it with
Okay.
Mr. Rolandi.
All right.
Okay. Thank you, Your Honor.
I just want to make sure you have a number, because I didn't, I thought it would happen before today, but obviously it doesn't seem to have happened. And again, he may not have received anything saying he's been appointed yet, so I'll follow up on that as well.
Okay.
All
Thank
right.
you, Your Honor.
Thank you. We'll see you on Friday.
Okay.
Mr. Kleins?
Your Honor, first I have on the docket is Bradley Anderson. Mr. Anderson is present and approaching. Your Honor, we'd announced plea or trial on the 25 CF 954 case. We can leave this set on the trial docket.
Thanks, Ray.
All right, so that's the 25 CF 954 is ready for trial?
Yes, Your Honor.
Okay. All right, how many days? One, I would assume?
I would imagine a day.
1 day, Judge.
Okay.
And I would think that we could do a pick and go. I'll leave it to the court's discretion, but I mean, it's not a complicated case with a ton of witnesses.
Okay, we'll talk about it more on
Sure.
Friday, once we know how many are going and what days are going to be available. As of right now, we've only got, this is only the third case confirming trial, so. All right, Mr. Anderson, we'll see you back on Friday, that's May 8th at 9 o'clock for purposes of jury review, and that's when we'll come up with what day your case is actually going to go to trial.
All right, thank you, sir.
All right.
Yeah. All right. I'll call you this week.
And then the 25 CF 955 case is just running along with it for purposes of control.
And the previous offer is revoked.
Okay. All right, Mr. Anderson, did you hear that? Mr. Anderson?
Sorry.
The state has now revoked its plea offer. Do you understand that?
Just in due course, I would expect, Mr. Kleins expected that.
Oh, yeah.
Okay.
Sorry, yes.
But just to put it on record, what was the plea offer, so it's on there that it's been conveyed?
Yes.
It was 24 months in the department.
24 months DOC?
Yes.
You understand that's no longer a plea offer? Okay, and do you understand that I won't be taking any other negotiated plea at this point? Okay, we'll see you on Friday.
Your Honor, I don't know if she's on Zoom, but Michelle Kahn, we had sent her Zoom contact information.
I haven't had anyone else on Zoom other than the one I just did.
Okay, we'll skip her for now. If she shows up, I'm going to stick around until the end of the docket today.
Let me just double check, but it'd been on for at least an hour and no one else was on.
Okay. Next in the gallery, I have Marcus Demmons.
I believe Ms. Khan wasn't here last week, right?
She was not. She's been in contact with my office, but she was not present last week. We filed a waiver, I believe. I'll check that. Your Honor, this is Mr. Demmons in 25 CF 1314. We have reached an agreement to resolve this. At this time, Mr. Demmons will enter a no contest plea as charged. The agreed upon disposition is that he will be placed on 1 year of probation. He will do a substance abuse evaluation and any recommended treatment. As a condition of that supervision, he would be assessed $615 in court costs, $150 in the cost of defense. I did not write it on the plea agreement, but because he is court appointed, the cost of supervision will be waived. He has previously been adjudicated. He would be adjudicated of this. May I approach?
Yes.
No objection to that solution.
Thank you. All right, Mr. Demmons, can you raise your right hand?
Raise your right hand.
Yes, sir. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Marcus Demmons, 10/10/95.
All right, Mr. Demmons, you're here in 25 CF 1314, charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, as well as driving while license suspended or revoked. Second conviction, it's a first-degree misdemeanor and punishable by up to a year in jail. Do you understand that?
Yes, sir.
I have a plea and sentencing agreement that would have you plead as charged. You'd be adjudicated guilty, so it's a felony conviction. It'd be 1 year probation, substance abuse evaluation, any recommended treatment, $615 court costs, $150 cost of defense, waive cost of supervision. Is that what you want to do here today?
Yes, sir.
Did you have enough time to go over this plea with your lawyer?
Yes, sir, I did.
Did you understand and sign the agreement?
Clear, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've read to you?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are on page 1 and going into page 2 of the agreement that you did sign?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the possession of controlled substance and driving while license suspended?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, 1 year probation, substance abuse evaluation, and recommended treatment, $615 court costs, $150 cost of defense, I'll waive cost of supervision. All right, I'm going to need your fingerprints, Mr. Demmons. You also have to talk to probation behind you. I do want to mention, Mr. Demmons, that you scored 39.50 points, so even a technical violation of probation would put you above 44 points, which means that you'd score prison at that point.
We have had that discussion.
Yes, sir.
Okay, well, now we have too, right, Mr. Demmons?
Yes, sir.
Okay. All right, you can be fingerprinted, 30 days to appeal the judgment and sentence of the court.
Next in the gallery, Your Honor, I
1
have
year each count probation, concurrent.
Devonta Frederick. And that'll be followed by Victoria McLeod. And this is Mr. Frederick in 25 CF 1273. I believe Mr. Sprouse has an announcement.
Yes, Judge. After depositions and speaking with the victim in this case, the state is going to null pros the case.
Devonta Frederick's case, 25 CF 1273.
Yes, Your Honor.
All right, state has dismissed your case, Mr. Frederick.
last I have in the gallery, Victoria McLeod. She is present in 25 CF 1000. I'll turn it over to Ms. Flowers. I believe she has an announcement. Yes.
McLeod. All right, state has entered a null process in this case as well. Case is dismissed, Ms. McLeod. Thank you.
Your Honor, I do have a plea agreement from Mr. Ewing. If I may approach, I will tell the court that he was here today.
Okay.
I went ahead and told him he could leave because it's a misdemeanor. I just realized it's battery.
It's a misdemeanor battery, so I need his fingerprints.
And so what I'm going to do is I'm going to contact Mr. Ewing, and I'm going to contact JCS and tell them that fingerprints have to be submitted. That's my fault. That is totally my fault. This was one of the plea or trial cases, though, so I
know it was.
want the court to be aware of that. What I'll do is I will see if I can get Mr. Ewing in court on Friday, just so he can...
Let's do that just to make sure of it. And I'll give you back the plea form so we have it. But I'd rather do it that way because not only are you making a condition of probation, but it's JCS probation who's not here to advise him.
Understood.
I want to make sure all that stuff, and he gets what he needs to report to JCS so he doesn't end up in a violation.
But he was here, so...
I understand, but he's not here now.
I know. As soon as I walked up to the podium, it occurred to me, so...
All right, let's bring him back for Friday, May 8th, 9 o'clock.
And then I have... The rest of my individuals are in custody. Your Honor, this is Mr. Jabari Fountain in 26 CF 28. Mr. Fountain is signing a plea agreement right now to resolve this case. The agreed upon disposition is that Mr. Fountain will enter a no contest plea as charged. He will be sentenced to 60 days in the Okaloosa County Jail with credit for all time served. He would be assessed court costs, 150 costs of defense. He would be adjudicated. He has previously been adjudicated. This is a downward departure, negotiated. If I may approach.
Yes. Thank you. All right, Mr. Fountain, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name and date of birth?
Jabari Fountain, 12/20/96.
All right, Mr. Fountain, you're here in 26 CF 28, charged with battery on a detainee, third-degree felony, punishment of up to 5 years in a state prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that would have you plea as charged as a felony conviction, as an adjudication, 60 days county jail, credit for time served, court costs?
687.
687 in court.
Sorry, 867.
867 in court costs, 150 costs of defense. Going to judgment, Mr. Clowns.
I was going to say, I talked to Mr. Fountain about that. He's going to request that the court consider giving him 90 days upon his release to set up a payment.
All right, 90 days from your release, Mr. Fountain, to pay those costs or set up a payment plan. This appears to be a downward departure.
Yes, Your Honor. May we approach briefly?
Yes. Basis for the downward departure would be the uncoerced plea. All right, have you had enough time to go over this agreement with your lawyer, Mr. Fountain?
I did.
Did you understand and sign it?
I did.
Are you satisfied with your lawyer's advice and representation?
I am.
Are you currently suffering from any mental health issues?
Not at this moment.
Okay. Have you been diagnosed with a mental health issue?
No, sir.
Okay. You take medication for mental health issues?
Not anymore.
So, were you diagnosed with a mental health condition that prescribed you medication at some point?
I was.
Okay, so I just asked you that question and you said you weren't. You need to be on a medication?
No.
Do you understand what you're doing here today?
I do.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind?
Exactly. Yes, sir.
You understand you're waiving your trial rights, which are on page 1 and going on to page 2 of the agreement that you stated you understood and signed.
Yes, sir.
You understand you're waiving all potential defenses that you may have.
Yes, sir.
And you understand that if you're not a U.S. citizen, you could be deported or excluded from the country based on this.
Yes, sir.
All right. And what is your plea to the battery on detainee?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 60 days county jail credit for all time served, $867 court costs, $150 cost of defense, 90 days from the date of your release on this case to pay your court costs or set up a payment plan. This is a downward departure based on a uncoerced plea bargain. I will need your fingerprints since it's a felony, Mr. Fountain, and you have 90 days to appeal the judgment and sentence of the court.
30 days, Your Honor.
What did I say, 90?
Yes.
I had the court cost.
I know you did.
30 days to appeal the judgment and sentence of the court. Excuse me.
Brady? After the records, you're ready.
Your Honor, this is Mr. Grady. I have been talking with Ms. Basso to resolve this. The state's current offer is known to Mr. Grady. We are going to ask that the court set this for a VOP evidentiary hearing with subpoenas. The purpose is that offer, I believe, is going to stay open until May 15th. If we accept it, we'll notify the court and obviously the state. If it's not accepted by May 15th, the offer will be revoked and we'll have that evidentiary hearing. But these cases have been going on for a while and we need to get them resolved one way or the other.
Frankly, Your Honor, the greater exposure is on the VOP, so we would be ready to proceed on that if we have not negotiated by that date.
What day would you like to?
What is available?
Well, I can tell you there's May 28th, but I know we've set some things there already. I'm also on duty that week, so I've got a lot more to do outside of the normal docket that day. I did want to discuss this with y'all as well. The following availability is June 4th. I may have to either cancel that day or move it up a day, if at all possible, because of a conference. So we could either try to do it on June 3rd, if that works for people.
That's fine for the state, Your Honor.
I mean, we can be ready.
And so I just confirmed that over the weekend, so.
Let me just double check to make sure my wife's not going to yell at me.
Okay. That is the chief concern of the court, Mr. Klein.
I'm sure you stay up at night thinking about that. Yeah, I'm good to go on the 3rd.
All right. Let's tentatively put it for June 3rd at 2 o'clock. I still have to confirm that with everyone that we can use that date. It shouldn't be a problem, but I just want to speak to everyone before we do that since it's kind of a change in the general calendar. All right, so that'll be for the VOP, June 3rd, 2 o'clock for an evidentiary hearing with subpoenas, and the two other cases will just ride along for control at this time.
Yeah, we're good.
Knopfinger?
Your Honor, this is Mr. Knopfsinger. I looked this morning, I did not see any notice of appearance filed on behalf of Mr. Knopfsinger. I did not see a written Nelson hearing motion. I don't know if the court's received one. That's the reason why I did not go talk to Mr. Knopfsinger on Friday is because there's a potential pending Nelson hearing request that I don't think was ever officially resolved.
On just a second. All right, and I checked it this morning. I didn't see anything had been filed. Mr. Knopfinger, did you intend to file anything?
No, Your Honor.
Okay. So are you ready to go forward to trial with Mr. Kleins?
Yes, Your Honor. I haven't been able to procure a private counsel, so.
Okay.
Still open to any pleas, but I doubt there's going to be any at this point.
Okay. Has a plea offer been conveyed, Mr. Kleins?
It was conveyed on February 11th. Mr. Knopfinger and I have discussed it at the jail, including up to last Monday, for over an hour. Ms. Basso revoked the offer last Wednesday, the 29th. So unless the state's willing to put it back on the table.
It was 50 years, Your Honor, followed by lifetime probation.
Mr. Knopfinger?
Is that as the statute charged or lesser pollutant lascivious statute?
Your Honor, we're not going to have negotiation on the record. If Mr. Klein wishes to speak to me on behalf of his client, we can certainly still do that today.
Okay.
We can pass him to the end of the docket. I'll talk to
Pass
Ms.
you
Basso.
ring back, Mr. Knopfinger.
Hold on, I'm here. Rainey?
Your Honor, this is Ms. Rainey. I did talk with Ms. Flowers this morning. What I would ask the court to do is to put Ms. Rainey's cases on the June 24th date as a control date. I am going to work with mental health court. There is a docket this coming Wednesday. I'm going to talk with Ms. Sharpless and see if we can get, she's already been accepted to mental health court.
Okay,
States-
my note said drug court, so maybe I put the wrong
Yeah,
one
it's,
down.
I know, but that's what's going on. That's the reason why I'm asking for the 6/24 date, but the intent is clearly to get Ms. Rainey into mental health court as quick as we can.
You understand that, Ms. Rainey?
I do, yes, sir.
Okay. June 24th, 9 o'clock for pretrial, but they'll probably have you in front of mental health court sooner than that.
Great,
All
thank
right.
you.
Yes.
Now I have court. Is that going to be? It's going to all be resolved. Okay. I'm good, thanks. Good day.
Your Honor, this is Mr. Tipton. He has reached an agreement with the state to resolve these two cases. The agreed-upon disposition in 16 CF 1262, Mr. Tipton will admit violating supervision. In that case, there is a 5-year suspended DOC sentence. Mr. Tipton would be sentenced to 60 months in the Department of Corrections with credit for time served. That supervision would be revoked and terminated. He would be assessed a $100 cost of prosecution, a $50 application fee, and a $100 cost of defense in that case. He has previously been adjudicated of that case. In 22 CF 894, Mr. Tipton on counts 1 and 2 is going to enter a no contest plea to violating Florida Statute 794011, subsection 8, subsection B. Counts 3 and 4 in that case will be no prost. The agreed-upon disposition for 22 CF 894 is that Mr. Tipton would be sentenced to 15 years in the Department of Corrections with credit for all time served. That sentence will run concurrent to each other, those two counts, and concurrent to the sentence imposed in 16 CF 1262. Following the 15-year sentence, Mr. Tipton would be placed on 15 years of sex offender probation. He would wear a GPS monitor while on supervision at $1 a day. There would be a predator designation. He will have no contact with the victims or family, including Robert Tipton, that is his son. No contact with any minors. Court costs, I did accidentally write on this plea form $150 in public defender fees. It should be $100 because he's been assessed the application fee on the 16 CF case. He would be adjudicated in 22 CF 894. May I approach?
Yes, is that the state's agreement?
It is a state's agreement, Your Honor. It is not a downward departure. We have discussed this with the victim and family.
All right, Mr. Tipton, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can put your hand down. Can you state your full name and date of birth, please?
Calvin Leon Tipton, 8/17/67.
All right, I'm going to go through these two separate pleas since they're on different forms. All right, Mr. Tipton, do you understand in 16 CF 1262, you're here on a violation of probation where you had a maximum exposure of 5 years in state prison? You understand that? I've got a plea agreement here that would have you enter an admission to your violation of probation. You'd be sentenced to 60 months or 5 years in the Department of Corrections with credit for all time served, revoke and terminate your probation, $100 cost of prosecution, $50 application fee, and $100 cost of defense. Do you understand that?
Yes, sir.
All right. And have you had enough time to go over this plea agreement with your lawyer?
I did, sir.
Did you understand and sign it?
Yes, sir.
No, you didn't. You missed that one.
Oh, I'm sorry. You know what? I need that other plea agreement. He has a copy of that plea agreement. I've been writing so many different versions.
No, no worries. Mr. Tipton, I didn't intend to mean that you didn't understand it, but just that you hadn't signed it.
You're gonna sign it right here?
I appreciate the, yes, sir. Today's date is 5/4. 26. That's the plea, VOP. And so the court is aware and the record is clear. Mr. Tipton has a copy of the plea agreement in this case. And he and I have discussed gain time issues. So he's aware that there's going to be no gain time on this plea.
Based on it being a 794 offense.
Correct. May I approach now?
Yes. All right, let's go back to where we were. So now, Mr. Tipton, did you understand and sign the VOP agreement? All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Anyone force, pressure, or threaten you to enter this plea?
No, sir.
Anyone promise you anything other than the terms of this agreement?
No, sir.
I understand there's not going to be a VOP hearing where the state would have to prove how you violated your probation. Do you understand that?
Yeah, we're not coming, we'll have to come back no more, right?
Yeah.
There's not going to be another hearing where the state's going to have to put on evidence that you violated your probation.
Yes, sir.
All right. Do you understand you're waiving any potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation
Yes, sir.
or exclusion from the country? All right. And what is your plea to the violation of probation? You're admitting or denying it?
Maybe.
I'll accept your admission as freely, voluntarily, knowingly given. Sentence you to 60 months in the Department of Corrections, credit for time served, revoke and terminate your probation, $100 cost of prosecution, $50 application fee, and $100 cost of defense. Those will be sent to judgment in that case. All right, and then I also have Mr. Tipton, you're here in 22 CF 894, where you're currently charged with sexual battery, counts 1 and 2. Those are punished by up to life in prison. You also have counts 3 and 4, which are lewd and lascivious molestation, also punished by life in prison, potentially. Do you understand that, sir?
Yes, sir.
I have a plea and sentencing agreement between you and the state that would call for you to plead to counts 1 and 2 as a violation of 794.0118B as in Bravo, which is first-degree felony and punishable by life in prison still. Do you understand that?
Yes, sir.
All right. In return, the state's going to dismiss counts 3 and 4. Is that correct?
That's correct.
All right. And the agreed-upon sentence is 15 years in the Department of Corrections, credit for all time served, concurrent to each other and concurrent to the sentence imposed in 16 CF 1262, followed by 15 years of sex offender probation. You must have a GPS monitor while you're on supervision. You will be designated as a sexual predator. No contact with the victims or family of the victims in this case, including Robert Tipton. No contact with any minors. And a $100 PD fee, and court costs on that would be
10, 18.
$1,018 in court costs. Is that your understanding of the agreement, Mr. Tipton?
Yes, sir.
And is that what you want to do here today?
Yes, sir.
Did you have enough time to go over this plea form with your lawyer?
I did.
Did you understand and sign this plea form?
Yes, sir.
All right, and are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
And do you, I've already asked you, but are you under the influence of any alcohol, drugs, or controlled substances, any mental health issues? All right, we just asked those questions in the VOP as well. Anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything other than the terms of the agreement that I just read to you?
No, sir.
You understand that if you enter this plea, there won't be a trial of any kind?
Yes, sir.
You understand that you're giving up your trial rights, which start on page 1 and go on to page 2 of the agreement that you've stated you understood and signed? You understand you're waiving any potential defenses that you may have?
Yes, sir.
You understand that by entering this plea, if you're not a U.S. citizen, you can be deported or excluded from the country?
Yes, sir.
You understand this plea would call for you to serve 15 years in the Department of Corrections?
Yes, sir.
Followed by 15 years of sex offender probation? And you understand that you'll be designated as a sexual predator based on a violation of 011-8B?
Yes, sir.
All right, and you understand, as stated by your lawyer, under the current statute, you're not eligible for any sort of gain time on your prison sentence?
Yes, sir.
All right. All right, based on all that, what is your plea to counts 1 and 2, the sexual battery charges?
No content.
I'll accept your no contest plea as to counts 1 and 2. State have an announcement on 3 and 4.
Yes, Your Honor, state would announce the null process counts 3 and 4.
As I stated, this is not, or I guess as the state has stated, this is now a downward departure. He scored 167.4 months. This would be 180 months, so it's over the guidelines. Do you understand that?
Yes, sir.
All right.
Your Honor, Mr. Tipton would request that the court recommend that he be sent to Calhoun Correctional Institution. I know that the court's recommendations aren't binding on the department, but he has asked the court to consider recommending a specific recommendation.
Based on what?
He's been there before. I was trying to think of the best way to phrase it. He's familiar with the institution. He's got prior experience there.
I don't think it'd matter if I did recommend it, Mr. Klein's, but also I'm not going to. All right, Mr. Tipton, you're to be fingerprinted. You'll have to talk briefly with probation, since you'll be on sex offender probation after your prison sentence. You do have 30 days to appeal the judgment and sentence of the court.
Yes.
All right, thank you. Supervision fees will be waived due to the fact that he's indigent.
And the GPS is $1 a day?
$1 per day on the GPS, unless it changes in some way between now and then. Sorry.
Probation on each count.
Probation on each count concurrent.
That's right. That's right. Sign and date it.
Statute that he pled to is not statute on the other side.
Hold on just a second.
Today is May 4th.
Hold on just a second, Mr. Tipton, there's a question. Yes, it's a lesser included because he was initially charged with a capital felony. That's a life felony. You can go ahead, Mr. Timpson, once you're done with your fingerprints. I'm sorry, Mr. Kleins, who is this?
This is Mr. Stephen Copeland.
Copeland. Oh, this is one that wasn't added.
Your Honor, this is Mr. Copeland in 25 CF 2171. We have reached an agreement to resolve this case. At this time, Mr. Copeland is going to enter a no contest plea to counts 1, 9, and 17. In exchange for the pleas on those counts, counts 2 through 8 and 10 through 16 will be dismissed. The agreed-upon sentence for Mr. Copeland is that he will be sentenced to 11 months, 29 days in the Okaloosa County Jail with credit for all time served. That will be followed by 2 years of probation. Special condition of supervision is that Mr. Copeland will pay restitution in the amount of $1,244 to Richard Stewart. His supervision will automatically terminate at any point after the 12 months, once all of that restitution is paid. So even if he pays it all within the first 6 months, he's still going to be on supervision until he hits the year. And I've also discussed with him, like, if you still have outstanding restitution, it's not going to terminate until the restitution is paid in full, even if it is after 12 months. So he will pay $615 in court costs, $150 in the cost of defense. He has previously been adjudicated, so he'll be adjudicated here.
May I approach?
Yes.
May I approach?
Yes. Thank you, Mr. Kleins.
The guidelines will come shortly. I didn't want to line
Okay.
this portion so much.
Is it a downward departure in any way?
I believe it will not be.
All right, Mr. Copeland, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Stephen Nicholas Copeland, 12/16/91.
I'm sorry, it's Copeland?
Copeland,
I'm
yes,
sorry, I've been mispronouncing that. Mr. Copeland, you're here in 25 CF 2171, 8 counts stealing stolen property. Those are each punished by up to 5 years in state prison. 9 through 16 are transaction fraud to a pawnbroker. Also, second-degree felonies punished by up to 15 years in state prison. Then count 17 is grand theft from a dwelling. Third-degree felony punished by up to 5 years in state prison. Do you understand all those current charges and maximums?
Yes, sir.
All right, I have a plea and sentencing agreement between you and the state that would have you plead to counts 1, 9, and 17. The state would dismiss the remaining, so that's 2 through 8 and 10 through 16. In return, it'd be 11 months, 29 days, Okaloosa County Jail, credit for time served, followed by 2 years of probation, $1,244 in restitution to Richard Stewart. Your termination, or your probation shall terminate early at any point after 12 months, so long as you've paid, or as long as you've complied with all conditions of your probation to that point, including paying restitution and costs. Do you understand that, Mr. Copeland?
Yes, sir.
All right, it'd be an adjudication of guilt, so that would be 3 felony convictions. Do you understand that? Have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it? Are you satisfied with your attorney's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read to you?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement that you stated you understood and signed? Do you understand you're waiving all potential defenses? And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right, Mr. Copeland, what is your plea to 1 count dealing stolen property, 1 count pawnbroker fraud, and grand theft from a dwelling?
I'm pleading no contest.
All right. I'll accept your no contest plea as freely, voluntarily, knowingly given to those 3 counts, adjudicate you guilty. State have an announcement on counts 2 through 8 and 10 through 16.
It's going to be no pros for plea to the other charges. This will be a negotiated downward departure.
I'm going to sentence you to 11 months, 29 days in the Okaloosa County Jail, credit for time served, followed by 2 years probation. You're to pay restitution of $1,244 to Richard Stewart, $615 court costs, $150 cost of defense. Your probation shall early terminate after 12 months if all conditions are met, including the payment of that restitution. All right. This is a downward departure. Do you have the guideline number?
Yes, sir. It's 107.80 points. As well as this being a negotiated plea, its need for restitution being a reason for downward departure as well.
Downward departure based on the need for restitution as well as an uncoerced legitimate plea bargain with the state. Mr. Cope, I need you to speak with probation. You also have to come up here and get your fingerprints on the way out, and you have 30 days to appeal the judgment and sentence of the court.
And supervision fees waived, Your Honor?
Yes, cost of supervision will be waived due to the fact that he's been found to be indigent.
Your Honor, this is Mr. Thompson. For today's purposes, I'm going to ask the court to continue this to the June 24th docket. However, I talked with Mr. Sprouse. We are in agreement, I believe, on the sentence. I have to confirm with Keaton that Mr. Thompson has been accepted to the program. So I did discuss this with Mr. Thompson, explained, look, we're going to put this, it's going to sound a lot far off, but the intent would be if we can get everything squared away by Thursday or Friday of this week, have him back before Your Honor to take a plea. Or I had even told him, like, even if it's something that maybe comes together next Monday. I know the court is going to be probably here for something with a jury. So I told him basically like...
Whenever I'm going to be sitting in this chair, you can sit it back up.
That's pretty much what I told him. I said, this first docket I can get you on once we get everything squared away.
Okay. All right, Mr. Thompson, we're going to put you for June 24th, but we'll move you up as soon as I get everything worked out. All right. That's June 24th, 9 o'clock for pretrial. Is that everything, Mr. Kleins?
I've got to go talk to Mr. Thompson.
Okay. Mr. Tony? All right.
Judge, I've got most of mine are going to be pleas, but I've got 2 cases that I think we can do really quickly.
Okay.
You want me to go ahead and do the first? Kalani Lewis. Judge, Ms. Lewis is sitting right outside with her child. Child's at the age where he tends to make noise.
Okay.
We've got a written deferred prosecution agreement in this case.
Okay.
Will the court allow me to excuse her and just file that with the clerk?
Has it been filed?
She just signed it this morning.
Okay. So has everyone signed it?
Yes.
Well, just file it and then she can go.
That's for a 6-month term, Judge.
You have the DPU? All right. We'll take Lewis off the docket.
Thank you, Judge. Judge, Mr. Hager is here. He's set plea or trial. His brother's with him. I've had contact with them since pretrial conferences. His brother did forward to me. They're seeking a continuance to hire other counsel. They have an appointment with Flaherty and Merrifield this afternoon at 4 p.m. I did advise the brother he might want to be here in case the court had any further questions for him. I think the brother and another family member are going to handle the payment.
Well, until he has another lawyer, his case is set for trial.
Yes, sir. In that case, what I'd suggest is we set it for the Friday date and see if they make an appearance
All right.
on or before then.
Oh, he's in custody.
Okay. He was, no, that's right. He was taken into custody. He was originally not in custody. Judge, while we're waiting, I can call Billy Lee Allen. Mr. Allen's going to be a plea.
Okay. Does he have this much credit?
Judge, I've got him at 122 days. He was booked on 4/7/25, and the bond was filed on August 7th of '25.
All right, give me the dates as you've got them.
I'm sorry, Judge?
Give him the dates as you have. That was April 5th he was arrested.
The offense happened on April 5th. I don't think he got booked until April 7th because he had the medical issue. He was shot. But they may have placed him in custody there at the hospital. So I'll go with April 5th if that's
I'm just trying to figure it out because otherwise I can have him taken into custody and the jail can do their normal memo unless there's an agreement on what is.
They did go ahead?
Yeah.
Okay. He's advising me that he was placed in custody at the hospital. But even using the later date, it's over 120 days.
Well, I've got the surety bond was signed on August 1st.
I'm sorry, Judge, what I had was the 7th. I
think that's what day it was filed. So I'm not sure he has 120 days. Again, I can't look it up on the jail website anymore because they took that part down.
Yes, sir. Yes, sir. So there's a possibility, or what it looks like is that they will take into custody, take it back at the jail, unless the state wants to just say time served. And I don't know that that's what they want. No.
All right, well then, if y'all want to figure it out, so he doesn't go sit in jail for them to figure it out, we can bring it back Friday. But Mr. Allen, if you don't have 120 days in, you're going to be taken into custody.
Judge, actually, I can probably figure it out for later today, but if Friday works, we can do it on Friday.
However y'all want to do it, Mr. Williams, but I can't be the one trying to compute all these things. The court's not supposed to tell people what their credit for time served is because you can't rely on what I'm saying. But from what I see, he doesn't have 120 days in.
Let's do this then. Sir, come back on Friday, and I will contact the jail and get the jail to calculate it for me.
I'd love to tell him what his credit is, but that's just not how it works, and I can't see anything anymore. But based on when the offense happened and when the bond has a signature on it, I don't think it's 120 days.
All right, Judge.
All right, we'll see you on Friday for purposes of the plea. Let me give this back to you, Mr. Williams.
Yes, sir. All right, come back on Friday, and I'll have a letter from the jail by then, or an email from the jail by then. All right. Okay, so you're done for today, but I'll need to see you Friday morning at 9 o'clock back here. All right.
Hager?
Judge, this is Cody Hager, 2025 CF 514. Mr. Hager, I've explained to the judge what your brother's doing about trying to hire an attorney for you.
Yes, sir.
And the judge's position is until a notice of appearance is filed by that attorney, you're still on for trial. So you're going to come back on Friday. Your brother's going to talk with the attorney at 4 p.m. today.
Yes, sir.
All right.
Thank you.
All right, just Mr. Hager, understand that if you don't have new counsel, my intent is to go forward with this trial. It was set for trial, you said you were ready for trial, and now you want new counsel, I understand, but we can't just drag these things out and change course like that. All right, we'll see you on Friday at 9 o'clock, May 8th.
Judge, if I can go back to the out of jail.
Sure.
Folks, try to clear the courtroom. Jeffrey Lee Johnson. Judge, this case was set for plea or continuance. We're looking at a no valid driver's license here, but Mr. Johnson was going to try to get some Okay. So I'm going to have to continue it, get those as soon as you can, and I'll get them to the prosecutor. Maybe we can bring you in early.
Okay. Continue it to when?
The next continuance date is going to be June 22nd. Or you got to wait until the judge?
Hold on.
This is the one that there was the mitigation. In fact, I think you've got a pending motion.
I tried to get a printout of what I've paid and what I owe, but they wanted like $23, I didn't have it, so. But I've tried to keep most of it paid up.
Prosecutor's wanting to see what efforts he'd made at clearing it.
All right, but the case is going to be over a year old, right, or just about a year old?
Yes, sir.
11 months old when we come back.
Yes, sir.
So these cases shouldn't take this long. June 22nd, 1 o'clock, last continuance.
Thank you, Your Honor.
Robert Rabnell Johnson. Judge, this is going to be a plea.
Mr. Johnson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Robert Johnson, 1985.
All right, Mr. Johnson, you're here in 25 CF 1085, charged with possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison, and possession of drug paraphernalia, first-degree misdemeanor, punished by up to a year in county jail. Do you understand that? I've got a plea and sentencing agreement that would have you plea as charged, adjudicate you guilty, so it's a felony conviction, 2 years probation, substance abuse evaluation, and any recommended treatment, random urinalysis. You need to sign up for that evaluation within 30 days. 6/15 court costs, $150 PD fee, and supervision fees would be waived. Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
Have you had enough time to go over this agreement with your lawyer?
I have.
Did you understand and sign it? Are you satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement I just read to you?
No, sir.
Do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your trial rights, which are on page 1 and going to page 2 of that agreement that you signed? And you understand you're waiving all potential defenses?
Yes, sir.
And you also understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country. All right, Mr. Johnson, what is your plea to the possession of controlled substance and possession of drug paraphernalia?
No contest.
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 2 years probation, substance abuse evaluation to sign up within 30 days. You have to do any recommended treatment, random urinalysis, 615 court costs, 150 PD fees, waive costs of supervision due to the fact you've been found to be indigent. I do need you to talk to probation, who's sitting there behind you, as well as be fingerprinted before you leave. You have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
Yes.
Based on the fact that he scored 33.60 points. All right, thank you, Mr. Johnson.
Thank you, Judge.
2 years, I'm sorry, it'd be 1 year on the paraphernalia, 2 years on the felony concurrent.
Tavares Kendall. Judge, this is likewise negotiated plea.
Mr. Kendall, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you turn that microphone towards him, Mr. Williams?
Yes.
I need you to speak up, Mr. Kendall. You're here in, I'm sorry, can you give me your full name and date of birth, please?
Lawrence Demond Kendall, 8376.
All right, Mr. Kendall, you're here in 25 CF 885, charged with fleeing to elude and driver license suspended as a habitual traffic offender. They're both third-degree felonies, each punishable by up to 5 years in state prison. Count 3, resisting without violence. Count 4, possession of paraphernalia. Count 5, also paraphernalia. Those 3 counts are each first-degree misdemeanors punished by up to a year in county jail. You also have 25 CF 886, possession of a controlled substance and tampering with evidence, both third-degree felonies and punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I have a plea and sentencing agreement that would have you plead to the fleeing to elude, drive on suspended, and resisting on the 885 case. The state would dismiss counts 4 and 5, as well as all of 25 CF 886. Do you understand that?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
All right, calls for 2 years of probation on the 2 felony counts, time served on the misdemeanor. You have to do a substance abuse evaluation, any recommended treatment, or the ECLC program, 615 court costs, 150 PD fee, waive cost of supervision. So that's the agreement that you've signed up for.
Yes, sir.
Do you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read to you?
No, sir.
You understand by entering a plea, there won't be a trial of any kind.
Yes, sir.
You understand you're giving up your trial rights, which are in the agreement that you understood and signed.
Yes, sir.
And you understand you're waiving all potential defenses.
Yes, sir.
And do you understand that if you're not a U.S. citizen, you could be deported or excluded from the country based on this?
Yes, sir.
Okay, what is your plea to the fleeing to elude, driver license suspended, and resisting without violence?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement as to counts 4 and 5 and all of 25 CF 886.
Yes, Your Honor, counts 4 and 5 will dismiss and will no pros 25 CF 886, Your Honor.
All right. Those cases, or those counts will be dismissed. As to counts 1 and 2, it'll be an adjudication of guilt, 2 years probation, ECLC, or substance abuse evaluation, any recommended treatment, 615 court costs, 150 PD fees. As concurrent, the misdemeanor will just be time served, waive cost of supervision. This is a guideline sentence as you scored 36.6 points. Mr. Kendall, I'll need you to be fingerprinted. You also need to speak with probation, and you have 30 days to appeal the judgment and sentence of the court. All right, thank you. Bob's back. 2 years total.
Was it 2 felonies?
Yes. 2 years concurrent.
Judge, next case that I've got is McLeod. Judge Anthony Dwayne McLeod, he's got 4 cases, 1990, 1990 was the one that was set plea or trial, the others were set plea or continuance. Mr. McLeod?
Have you seen him this morning?
No.
Now afternoon?
Or if I have, I didn't recognize him, I guess I should say.
He was here on April 27th for pretrial conference. It was set for today, May 4th at 9 a.m. It's now 12:03 p.m. Via capias with no bond for Mr. McLeod.
Next case.
That's all cases.
Yes, sir. Next case I have is Oral Mitchell. This is a negotiated plea.
Mr. Mitchell, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
9651.
Say again? I couldn't hear you, Mr. Mitchell.
I can't quite hear you.
Your name and date of birth, please.
You got to state your name first.
Oral Mitchell,
And what's your date of birth, sir?
9651.
Okay. All right, Mr. Mitchell, you can put your hand down. You're here in 25 CF 2074, charged with 2 counts of failure to register. Each are third-degree felonies, punishable by up to 5 years in prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that you plead to count 1. State will dismiss count 2, be an adjudication of guilt, 6 months community control, GPS at $1 per day. Court costs would be...
$515.
$515 in court costs, $150 PD fee, waive costs of supervision. All right, Mr. Mitchell, is that your understanding of the agreement?
Yes, sir.
Is that the state's agreement?
It is the state's agreement, Your Honor.
All right, I see that he scores 4 points.
Yes, Your Honor, that is only a level 1 based on the subsection that it is violated.
Okay. All right, Mr. Mitchell, have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Okay. Is that your signature there?
Yes, sir.
Okay. And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand if you enter a plea of no contest, there won't be a trial of any kind? Do you understand there won't be a trial if you enter a plea?
Yes, sir.
Okay, and do you understand you're giving up your trial rights, which are listed in the agreement on page 1 and 2, the agreement that you signed?
Yes, sir.
You understand that?
Yes, sir.
You understand you're waiving all potential defenses that you may have.
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And Mr. Mitchell, what is your plea as to one count of failure to register?
Say no.
No,
No contest.
no contact.
I'll accept your no contest plea as freely, voluntarily, knowingly given, Mr. Mitchell. That's just to count one. State have an announcement as to count two.
Yes, Your Honor, the state would not pass count two, return for the plea to count one.
All right, adjudicate you guilty, 6 months of community control, GPS monitor at $1 per day, $5.15 court costs, $150 PD fee, waive cost of supervision. That is a felony conviction, Mr. Mitchell. I need you to be fingerprinted, then taught to probation, and you have 30 days to appeal. This is a guideline sentence as he scored 4 points.
Thank you, Judge.
All right,
Judge, I apologize, it's 666.
666 court costs. I apologize for that, Mr. Mitchell, but 666 in court costs.
Your Honor, if I may.
Yes, sir.
Sean Cobb, my office did get a hold of him, Your Honor. He thought court was at 1. He's on his way now.
Okay.
He lives here in Crestview.
That's all that I have that's out of jail, Judge.
Okay. Mr. Tony?
Randy?
Afternoon, Your Honor.
Afternoon.
The first matter is State of Florida versus Joshua Ramsey. We have 2 cases for Mr. Ramsey, Your Honor. That one is 26 CF 77, and the other is 251091. We have a tentative agreement, Your Honor. However, we still need to work out some things, and to the extent that it's going to cause for incarceration anywhere, we would just hope to kind of push this to probably the miscellaneous docket if we could get it.
Well, you want to do it Thursday or Friday this week?
That'll be fine. Can we get it done by then? Cody?
Yes, I was thinking, I'm sorry. I can get it done.
All right, let's just do Friday then, if that works.
And that'll be Friday morning?
Friday morning, 9 o'clock. It's May 8th, 9 o'clock for a plea.
And we have State of Florida versus Byron Williams Jr. in cases number 2025 CF 1958 and 25 CF 1131. Pursuant to negotiation with the state, Your Honor, we've reached a tentative agreement on this.
Okay.
Your Honor, I filed a motion for youthful offender, and to the extent that me and the state have stipulated to it, this sentence would be predicated on that.
It's part of the negotiated plea?
Yes, Your Honor.
Okay.
I suppose it is, because it matters.
Okay. I just want to make sure that I'm missing anything.
In jail, man. May I approach, Your Honor?
Yes.
Your Honor, with regards to 2025 CF 1958, under the youthful offender status, my client will have 5 years of community control probation sanctions. He will be responsible for any restitution, if any, and he also will be responsible for any court costs associated with this matter. With regards to case number 2025 1958, 2025-1131, I think the state has an announcement with regards to those 3 charges.
That case is going to be null pros for a plea to the other case.
So you're dismissing 1131?
Yes, 1131. By victim's request.
Okay. So it's all in here still, so. You want me to cross this all off? If you're
I'd be fine
dismissing
with
that case? Well, I was a little confused with the motion that talks about it being a first-degree felony, but except that case is being dismissed, and it's all in here, and.
Yeah, we just got to that point.
I understand, just. So is it still going to be the 5 years of community control on the 1958 case?
Yes, Your Honor.
And what is the intent with the youthful offender?
Well, that was to get to where we are now, with regards to negotiating a plea and stuff. My client is an 18-year-old man. His family is about to relocate to I think, Atlanta, or Douglasville, somewhere around that area. He needs an opportunity to not have an adjudication of guilt for a felony on his record. And that's the whole preference that we are coming behind.
Well, he can get a withhold without youthful offender, right?
It went into the consideration of the state. I think that's what the intent of the motion is. So
Any issues with transferring community control out of state?
It's not gonna work.
Yeah. That's, my understanding, other states won't accept community control. I think Georgia specifically will not take community control. Why don't we pass it and y'all discuss how you want to handle this? I just don't want it to be where it seems like I'm part of it and telling y'all what you should do, but I can only do what's legally allowed. So, we can recall later today. I just want to make sure that y'all have it done in a way that's going to work, because if you try to send it to Georgia, they're going to reject it, and then what? Yeah. I have to make sure people are making decisions based on what we expect the consequences are.
We're going to talk about it. And the last matter, Your Honor, I have is State of Florida versus Donald Stewart Hinton. That's 2025 CF 1283. Now, Your Honor, in this particular case, we had an agreement, and then we didn't have an agreement. And then we lost the prosecutor, then we got a new prosecutor who's more sympathetic to my client's plight. If we could just pass this in miscellaneous day, I think we finally have resolution. And it was set for plea or continue with anyone, but I don't think we need.
Do you want to put it on Friday?
Friday will be good.
Thursday is just going to be a little bit more of a hectic day, so that's why I'm saying if it's just going to be a quick plea, let's put it on Friday. All right. Friday, May 8th for a plea. Pending. So otherwise, we probably have, let's look while we're here. Thursday doesn't look terrible, actually, in the morning.
Give me an opportunity to talk to the state about Williams, Your Honor, and
okay.
I guess we should come back this afternoon. Or you want to?
I was hoping to just finish up, but I'm not sure how many more
we can have
we've got.
5 minutes, that'll be fine.
Sure, take your time. We'll get to something, but it's already 12:17, and I'm not sure how much longer we've got until we're going to just take a break. I've been trying to get everybody out of here that I can, but.
5 minutes.
All right.
May I approach with a score sheet from
Yes.
earlier?
What did he get, 2 years probation?
That's correct.
Okay.
Thank you, Judge.
Mr. Williams, I have to find out.
Hopefully.
Hager.
Who's this?
William Hager.
Judge, this is Ms. Hiker.
Hiker, okay.
The state's going to dismiss the new law violation, and we're going to ask the court to dismiss the violation of probation. This will return her to finish up her probation, which I think is going to probably be around next July, maybe a couple of months later.
All right.
Judge, this, on the new case, the victim requested to drop charges.
That's 26 CF 7-8.
That's correct.
Okay.
And the violation is solely based on that?
Okay.
Yes, sir.
So what is the state doing in 26 CF 7-8?
We are dismissing the new law violation.
Okay. Any objection to dismissing the VOP?
No, Judge. We're asking for
All right.
that.
VOP will be dismissed based on the state's dismissal of the new charge, which is the sole basis of that VOP. Thank you. But you're still on probation, Ms. Hiker.
Yes, sir.
All right, what, reinstated, why don't you talk to him real quick so you know what you're dealing with?
Yes.
All right, Judge, this is Catherine. Oh, you're all right. This is Catherine Hughes. We had tried to enter a plea last time. There were some issues. I think we've gotten it all straightened
Okay.
out now.
Oh, thank you. Let's see. I'm sure I asked this the last time. Does she have the 90 days credit already?
She does, Judge. She's got around 120.
Okay.
A little bit more than that now.
All right, Ms. Hughes, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth?
Catherine Edith Hughes, 31063.
All right, you can put your hand down, Ms. Hughes. You're here in 26 CF 201, where you're currently charged with aggravated assault on a victim over the age of 65 as a second-degree felony and punishable by up to 15 years in state prison. Also, battery on law enforcement officer, which is a third-degree felony, and punishable by up to 5 years in state prison. Do you understand your current charges?
Yes, sir.
All right, I've got a plea and sentencing agreement that would have you plead to count 1 and an amended charge in count 2 of resisting with violence. That's Florida Statute 843.01. Under the terms of the agreement, it'd be a withhold of adjudication, 90 days county jail with credit for time served as a condition of 3 years of probation, $967 court costs, $150 PD fee, no contact with Daniel Hughes except through counsel. Ms. Hughes, you may attend court hearings and mediation in your family law case that's related to this. Defendant, even though he'll be there, just don't have any further contact with him other than is allowed by the court. Defendant may seek modification of the terms of her probation to change any sort of contact issues if necessary, but everyone has the right to ask the court to modify it. It's just not going to be automatic. Defendant shall also have one-time visit with law enforcement to go back to the house to collect your driver's license, identification, credentials, tools of the trade, and minimal personal items. And I'll also waive the cost of supervision due to the fact that you're represented by the public defender and found to be indigent. Is that your understanding of the terms of the agreement, Ms. Hughes?
Yes.
Is that the state's agreement?
That is, and it's in accordance with Marcy's law. I spoke with the law enforcement victim.
Perfect. All right. And Ms. Hughes, have you had enough time to go over your plea agreement with your lawyer?
Yes.
I just need you to speak up a little bit, Ms. Hughes.
Yes.
Okay.
Yes, sir.
And did you understand and sign the agreement?
Sir. Yes, sir. Sorry. Yes, sir.
Okay. Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've just read to you?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of that agreement you signed?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right. And what is your plea to the aggravated assault on a victim over 65, as well as resisting with violence?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, and knowingly given. I'm going to withhold adjudication, 90 days jail as a condition of 3 years probation, $967 court costs, $150 PD fee, no contact with Daniel Hughes except through your counsel in your family law case. You may attend court hearings and mediation related to that case without this being a violation of your probation, so long as you don't have any contact outside of normal course of that hearing or mediation. You can seek to modify the terms of your probation, one-time visit with law enforcement back to the shared home to collect your driver's license, identification, credentials, tools of the trade, and your minimal personal items. I'll waive cost of supervision as well. Ms. Hughes, this is a guideline sentence as you scored 41.4 points. What I'd like to point out, though, is that even a technical violation of your probation will give you 6 points, which would put you over 44, which is the threshold for a prison sentence. Do you understand?
Yes, I have a question.
Sure.
I thought I was at 39 points.
Well, because of the change in charge from battery on law enforcement to resisting, it's a higher level, so it added 1.8 more points.
Oh, okay.
But even if you were at 39.6 and add 6 to that, you'd still be over 44.
Okay, thank you.
And it's interesting enough that the bat on Leo has a minimum mandatory, but it's a lower level. So that's why it's a higher.
Minimum mandatory adjudication, right?
That's correct.
Yes. Which is what part of the issue when I was taking the plea last week is I can't withhold adjudication on a battery on law enforcement officer.
Yes, sir.
But it's now been changed. All right, Ms. Hughes, I need you to speak with probation. I also need, well, I don't need your fingerprints. Well, I do, because it's no, it's not a battery charge. John, thinking out loud a little bit here, we've had a lot of difficult issues to get through on your plea. So I don't need fingerprints because it's a withhold and it's not an enhanceable charge.
At 65.
It's ag assault, 65. All right, so Ms. Hughes, you have 30 days to appeal the judgment and sentence of the court. Again, you have to speak with probation before you leave. I won't need your fingerprints.
Okay.
Thank you.
Jackson?
Okay. Oh, okay, thank you.
Okay.
Wait here.
No, ma'am. Go. You go over here. Mr. Jackson, you come here. All right, Judge, we got a negotiated plea in this case. This is on the older case. Mr. Jackson's going to be entering a plea to the lesser offense of sale, manufacture, or deliver. We are specifically reserving our right to appeal the court's denial of his motion to suppress, and the state's agreed to stipulate that that motion was dispositive in the case. He still has the other matter set, but we're not in a position to go to trial on that.
Okay, just to make sure I'm clear, so in 24 CF 58, he was charged with trafficking in methamphetamine, which is punished by up to 30 years in prison as a first-degree felony, introduction to contraband, and possession of cocaine, both are third-degree felonies, paraphernalia, first-degree misdemeanor. There was a suppression motion that the court ruled against him, did not suppress the evidence. State has offered 3 years of probation on a lesser charge, so no longer trafficking, just possession, 893.132B. And then you're reserving on your right to appeal that ruling on the motion to suppress, and the state stipulates that motion was dispositive in this case.
That's correct. And if you would like more explanation for the change.
If you'd like to give more explanation, you're free to do so, Mr. Sprouse.
We had a witness issue with this case. That is why the offer is what it is.
Okay. All right, Mr. Jackson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name, please?
Michael Lynn Jackson Jr.,
All right, and your date of birth?
September 30th, 1982.
Okay, you're hearing two cases, but we're only handling that one today, which is 24 CF 58. Did you hear the charges that I had stated that you are currently charged with?
I did.
Okay, and the trafficking charge also had a minimum of 3 years state prison, the way it was charged. Do you understand that?
Yes, sir, I do.
All right, so the plea and sentencing agreement, as I have announced, it's a lesser possession with intent sale manufacture. 2, 3, and 4 would be as charged, correct?
Judge, actually, my understanding is the state's going to go ahead and just dismiss those.
That's correct.
Okay, well, let's just don't see how that's here, but if that's what the state's going to do, it's fine. It's not in the plea agreement. All right, Mr. Jackson, did you understand this plea agreement?
I do.
All right, and did you have enough time to speak with your lawyer about it?
I have.
All right, and I don't have any signatures on it.
Sorry, I'm confused by that, Judge, but I'll fix it. I think I wound up inadvertently pulling and writing on one of my copies. Let me get your signature right there.
Okay, right there, all right. Agreement, all right.
I normally make 3 copies. In this case, I think I wound up making 6. Basically, it's that. Well, I'm not sure. It might not start until we get out.
Can we ask and see?
Score sheet's up there, right?
I've got the score sheet.
The one with the one charge, the score
Yeah.
sheet. Cool.
Thank you. All right, now, Mr. Jackson, did you understand and sign the plea agreement?
Yes, I do.
Okay, and are you satisfied with your attorney's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir. I do have one question, though.
Sure.
Is the probation to start after this court date, or is it going to be after my release from incarceration?
Have y'all discussed that?
Judge, we haven't discussed it. I assume that there's, procedure in place. My thinking was that always that it would go ahead and start, but of course, he's not going to be able to report in until he's out of jail.
So he's going to start probation while he's sitting in jail
Well,
on a new offense that happened while he was on bond for this one?
No, Judge.
And just let it start and run?
That would not be the state's intention.
Then he can start it once. Yeah, he and I have not discussed it. He just asked me the question when he asked me.
I would say that his probation will be told until he gets released from jail.
All right, Judge.
All right. Are you suffering from any mental health issues, Mr. Jackson? I think that's when you asked that question, isn't it?
No, sir, I'm not.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir, they haven't.
Has anyone promised you anything other than the terms of this agreement?
No, they have not.
You understand if you enter a plea, there won't be a trial of any kind?
I understand.
And do you understand that you're giving up your trial rights, which start at the bottom of page 1 and go on to page 2 of that agreement you've signed?
I do.
And you waive those rights?
Yes, sir, I do.
Okay.
According to what we discussed, yes, sir.
Okay. And do you understand that you're waiving any potential defenses?
Yes, sir, I think that's correct, yes, sir.
All right. And do you
Judge, if
understand?
you could clarify, we're talking on this case. I think that's why he's being a little hesitant.
Well, I specifically said we're only talking about this case, but if you need me to say that again, I can. This is only regarding the 24 CF 5A. He's not waiving anything to do with his other case, which is 26 CF 229.
Yes, sir.
Okay. And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country, Mr. Jackson?
I do, I am a U.S. citizen, though.
Okay. All right, and what is your plea as to count 1, lesser included possession with intent to sell, manufacture, or deliver a controlled substance?
No contest.
Okay. And is that a second-degree felony?
Second-degree felony, yes, Judge.
Okay.
L5.
Just want to make sure, second-degree felony. So that means if you violate your probation, you can get as much as 15 years in state prison. Do you understand that, Mr. Jackson?
Yes, sir.
I just want to make sure it's clear since,
I didn't, but I do now, though.
okay.
Yes, sir.
All right, do you need any more time to discuss that issue with your lawyer?
No, sir.
Obviously, you don't violate your probation, and it will never come up, but
Yeah.
just want to make sure you understood, because it took it from a maximum of 30 to a maximum of 15.
Still a good
Okay.
deal, yes, sir.
All right, and what is your plea to that charge?
No contest.
All right, I'll accept your no contest plea to the lesser included possession with intent to sell, manufacture, or deliver, second-degree felony. State, have an announcement as to counts 2, 3, and 4.
Old Prosper to plea to count 1.
All right. 2, 3, and 4 have been dismissed by the state. Count 1 is going to be adjudication of guilt, 3 years probation, substance abuse evaluation, any recommended treatment, $615 in court costs, $150 PD fee, waived costs of supervision. Probation time will be told until you're released from jail. But also, you specifically have reserved your right to appeal the motion to suppress that this court ruled against you on. And the state has stipulated that that motion is dispositive of that case. All right. This is a guideline sentence, as you scored 36.40 points, Mr. Jackson. I need you to speak with probation. You have to be, that is adjudication of guilt, so I don't need your fingerprints for that felony conviction. And then you have 30 days to appeal. So make sure that you handle that and talk to your lawyer. If you can't afford a lawyer to appeal your case, one can be appointed for you.
And then the next court date for the 2026 case would be?
Will be June 24th at 9 o'clock.
Okay, thank you.
All right, thank you, Mr. Jackson. Speak with probation first.
Judge, this is Victoria Keebler.
All right, Ms. Keebler, can you raise your right hand? Right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please?
Victoria Keebler.
What's-
28, 2005.
All right, Ms. Keebler, you're here in 25 CF 2085, where you're charged with aggravated battery on a law enforcement officer. That's a first-degree felony punishable by up to 30 years in state prison, and ag assault on a law enforcement officer, which is a second-degree felony punishable by up to 15 years in state prison. Do you understand that? I've been given a plea and sentencing agreement that would have you plea as charged. You'd be adjudicated guilty, so that's 2 felony convictions, 36 months in the Department of Corrections, $967 in court costs, $150 PD fee, reserved jurisdiction for 90 days for purpose of restitution. And all your fees would go to, or all your costs and fees would just go to judgment. All right, is that the agreement as you understand it? Is that the state's agreement?
Yes, sir.
All right, and it looks like she scored 34.50 points, so this is a guideline sentence. All right, Ms. Keebler, did you have enough time to go over this agreement with your lawyer? Did you understand and sign the agreement? All right, and are you satisfied with your attorney's advice and representation? I just need you to speak up a little bit, Ms.
Yes, sir.
Keebler. Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
Yes, sir.
Okay. And has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I just read to you? Do you understand by entering a plea there won't be a trial of any kind? And do you understand that you'll be giving up your trial rights, which are on page 1 and go down to page 2 of that agreement that you signed? And do you understand you're waiving any potential defenses that you may have? And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? And what is your plea to aggravated battery on a law enforcement officer and aggravated assault on a law enforcement officer?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, 36 months in the Department of Corrections, $967 court costs, $150 PD fee, reserved jurisdiction for 90 days for purposes of restitution. All fees and costs will go to judgment against you, Ms. Keebler. I do need you to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. As I stated, you scored 34.5 months, and this is a 36-month sentence. All right, thank you. Please step up to be fingerprinted.
36 months each.
36 months each count to run concurrently.
Judge, we don't have an agreement. I think that we...
Who's this, Mr.
This is
Williams?
Mr. Mattingly.
Yes.
It's 4625, 1642. It was set plea or continue. I think that if I go out and speak with him again, I can answer his questions and get us there. But he's asking me to make some counteroffers, so I'll need to make those. Is the court amenable to passing this perhaps even Friday? For me to try to to get it resolved this cycle, or does the court want me to just go ahead and continue it, and maybe bring him in early if I get it set up?
State, you want to put him, it looks like Thursday is not as bad as I thought it was. You want to do Thursday or Friday?
Thursday's fine, or Friday, either one's fine with me, Judge.
State, anyone? Mattingly?
Mattingly, it's Ms. Flowers' case. No, ma'am, he's asked me to make a counteroffer.
Thursday's fine.
All right, Thursday at 9 o'clock, May 7th.
Thank you, Your Honor.
Thank you, Judge, and I'll speak with Ms. Flowers.
Nichols?
I'll come out and talk with you. Judge, this is Mr. Nichols. It was set for plea or continuance. For today, I was trying to get the state to see the legal issues my way. That hasn't happened. I'm going to probably just file a motion in limine to try to restrict argument at a later trial, but it's not set for trial this time.
You're asking for a continuance then?
I'm going to have to, Judge.
June 24th at 9 a.m. pretrial conference.
Earlier to resolve it. I'll come out and I'll get information for that, and that I can probably get you set on fairly quickly. Okay? All right.
Mr. McLean. All right, you're Interiors McLean. All right, Mr. McLean, what's the status on hiring a lawyer?
My mom, she get back in town today. That's what I was waiting on, my mom to get back.
Okay.
You can appoint me one if you want to, but I'm
It's not about what I want, it's about what you want.
Oh, I'm gonna have one before Friday. My mom, she in West Palm Beach.
Okay. Have they talked to an attorney?
Yes, sir, they already have. I'm just waiting on her to get back so she can make the payment.
Let's put them on for status for Thursday at 9 o'clock. I just don't want to not appoint.
I have it Thursday.
Mr. McLean, that's what you'll come and tell me, that someone has actually been hired and is going to represent you when we get back Thursday. Otherwise, I'm going to end up continuing your case for almost 2 months. And if I find out you never hired an attorney, no one's going to be working on your case. So I keep bringing you back to make sure it actually happens. Because I'm not going to appoint a lawyer when you're telling me you can afford one, because you're hiring one. Thursday, May 7th, 9 o'clock, status on lawyer. Thank you, Mr. McLean.
You ready?
Yes.
Mr. Tony.
Judge, I'm going to try to duck out and talk to Mr. Mattingly.
Okay.
We resolved the issue, Your Honor, with regard to Mr. Williams. His
Okay.
family's advised me they won't be moving to Georgia. So now-
They won't be moving to Georgia?
Correct.
All right. All right, so, but it's still going to be 5 years of community control on the 1958 case?
Correct.
All right.
I think that
What?
Your Honor, the maximum period of time they can get on community control is 2 years. Unless y'all want to work something and run it consecutive and do something crazy.
Why?
I can find out the answer.
I don't remember ever hearing anyone getting more than 2. I'm not,
Yeah, I'm sure the state wouldn't mind 2 years of community control.
I'm leaning that way.
say again?
If we do 2 years community control, followed by 5 years probation, that is,
3 years probation, so it would be 5 years total.
sorry.
All right, this is what I'm going to do. I'm going to take about a 10-minute recess, and no offense, I don't want y'all to talk this out, but I haven't stood up in 3.5 hours. So if we can just take a 10-minute recess, y'all take care of this and how you all want to do that. Make sure you're reading the statute and what's allowed and what's not. And then we'll be back in about 10 minutes.
All rise, court is in recess.
Slingerland. I don't see Ms. Slingerland in the courtroom. I know the court had said if she wasn't here today, the court was going to issue a capias. I would ask the court to consider an ROR bond on that capias. She was in court last week. I did talk to her last week. She left without me telling her to leave. And I can't get in touch with her, but based on the fact she was here last week, I would ask the court to consider an ROR bond on that capias.
And I would just ask for a cash professional bond, and leave the amount to Your Honor's discretion.
Statute number.
Can I borrow your pen? Mine's green. You had the score sheet, correct?
Yes.
Make sure. All right, let's see. All right, sir, thank you. And that's back to you. Thank you, then.
All right, for Slingerland, it's going to be a capias, or I'll just say it's set at first appearance. That way, if there's some issue, it can be brought up during first appearance. But I'll leave it at that.
Sure. Your Honor, this is Mr. Knopfsinger in 23 CF 2422. Mr. Knopfsinger has reached an agreement with the state to resolve this case. He is currently charged by indictment. Mr. Knopfsinger is going to enter a no contest plea to 2 counts of lewd and lascivious molestation. And I've written the statute number 800.04 subsection 5B, as in boy. The agreed upon disposition on count 1 would be that Mr. Knopfsinger will be sentenced to 600 months in the Department of Corrections. That is 50 years, 50. He will get credit for all time served. That will be followed by lifetime probation with a GPS monitor on at $1 a day for supervision. Special conditions would be no contact with minors. And if I think I said lifetime sex offender probation, it's sex offender probation, so we're clear. No contact with any minors, predator designation. He would be assessed court costs, $50 application fee, $100 cost of defense. Count 2 is another 50-year Department of Corrections sentence with credit for time served. That will be concurrent to count 1. That will also be followed by lifetime sex offender probation. The 2 counts mirror each other, the exact same. So the no contact with minors and the predator designation. He would be adjudicated. He has never been adjudicated before. If I may approach?
One question.
Yes, sir.
Mr. Kleins, you had sent an email to my office in the state about a potential motion to suppress evidence.
I've discussed that with Mr. Knopfsinger, and what I'm going to do is I'm still going to file it just so it's in the record, but that's.
You're going to file it in the record, but it's not being pursued?
Correct. We are, Mr. Knopfsinger, I should say, is deciding to dispose of this with the negotiated plea terms rather than go to trial. But I did discuss with him, and I told him essentially I'm going to mail him a copy, just so he has a copy of it. But I mean, it took me about 3.5, 4 hours to write, so I figure it should be in. The only reason.
Has he seen it yet?
He has not seen it, but he knows, and last Wednesday kind of went off the rails a little bit. He and I have discussed this motion at some length before it's been filed, so he knows what the basis is, he knows what the arguments are, but I am going to give him a copy of the formal motion. But I didn't file it yet because I wasn't sure if he was going to want to keep me on as a lawyer, and I don't think it would be proper to file something on behalf of a client who might has a pending Nelson.
I understand. I'm just trying to make sure, since once this plea is taken, if there's some sort of attempt to bring that back for that reason.
And that's one of the reasons why I want it to be in the record. It's not a dispositive motion, and so.
Okay.
Generally, Your Honor, aren't pending motions withdrawn?
Well, they're not even filed at this point, is the issue. But what I want to make sure, and I'll discuss this with Mr. Knopfsinger, if you could raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please?
Aaron David Knopfsinger, August 6, 1996.
All right, Mr. Knopfsinger, you're here in 23 CF 2422, where you're charged with 2 counts of sexual battery on a victim under 12, which are capital felonies, correct?
Those are.
But punishable by life in prison. All right. I've been handed a plea and sentencing agreement that would have you plead to 2 counts of lewd and lascivious molestation. That's a victim under 12, correct?
That is correct, Your Honor. That is also life.
That's also punishable by life in prison. It'd be Florida Statute 800.045B as in Bravo. The agreement is on each count, it would be concurrent, but 50 years in the Department of Corrections, or 600 months. Credit for all time served, followed by lifetime probation, that's sex offender lifetime probation, GPS monitor. While on supervision, you're also to have no contact with any minors. You'll be designated as a sexual predator. Costs? $817 in court costs. $50 application fee, $100 cost of defense. It'd be the same for count 2. They're to run concurrent. It'd be adjudication of guilt. All right, do you understand all that, Mr. Knopfsinger?
Yes, Your Honor.
All right. Now, just to discuss a couple of things, last week you had some concerns about your counsel and talked about potentially hiring new counsel and you wanted him off your case. I asked you to put that in writing if that's what you wanted to do, although we did discuss it some at last week's court hearing. Are you concerned at all at this point as to whether or not Mr. Kleins has been ineffective for you? No? All right. Now, you had at least one lawyer before Mr. Kleins, right?
I had 2 before him.
2 before him. Any concerns that they did anything that was ineffective in some way during the course of their representation? Okay. Have you discussed this issue regarding the motion to suppress that we were just talking about? Have you had a chance to discuss that with Mr. Kleins?
Yes, I have, Your Honor.
Okay. So do you understand the issues there? Okay. Now, Mr. Kleins has written a motion but has not filed it at this point. Do you feel the need to read over the motion first before you make a decision to accept this plea?
No, Your Honor.
All right. Do you also agree that that motion would not be dispositive of this case, which means if it were filed and set for hearing and granted, it would dispose of your case completely.
He's saying that, I'm sorry, it was a little confusing, but I have explained a dispositive motion ends the case. If the defense wins, it ends the case.
Okay.
Because what we were seeking to suppress were statements made to an officer, there were other statements made to other individuals, in addition to the allegations made by the victim himself. So that's why I was saying it's not a dispositive issue. There's other ways the state can try to prove this.
Okay. Do you understand that, Mr. Knopfsinger?
Yes, Your Honor.
That even if that motion were filed and I were to grant your motion, preventing that evidence from coming into the record, that the state could potentially still prove their case through other means?
Yes, Your Honor.
Okay. Do you have any other questions before the state talks to you about accepting this plea?
No, Your Honor.
All right.
Your Honor, if I may, there is
Please.
one additional provision I want to be clear on. Mr. Klein stated with no contact with minors. We'd also specifically like to say no contact with the victim or the family, because at some point they will, of course, be over 18 in the pendency of a sentence.
All right, so it'd be no contact with minors, but also no contact with the victim and the victim's family.
There's already no contact orders in place.
Okay, I understand, but this court is going to address it as well. Any concerns with that? Okay. All right, Mr. Knopfsinger, have you had enough time to discuss this plea agreement with your lawyer?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Did you sign it? Are you satisfied with your attorney's advice and representation throughout this case?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? All right, and how old are you, Mr. Knopfsinger?
29, Your Honor.
And how far have you gone in school?
Graduation.
Of high school? Okay, and do you read and write the English language well? Okay, so were you able to read through this entire agreement yourself?
Yes, Your Honor.
Okay, and you said you understood it, correct? Were there any questions that Mr. Kleins hasn't answered for you?
No, Your Honor.
Any objection to the score sheet, Mr. Kleins?
No, Your Honor.
Okay. All right, Mr. Knopfsinger, has anyone forced, pressured, or threatened you in any way to enter these pleas? Has anyone promised you anything other than the terms of the agreement I've read to you? Do you understand there won't be a trial of any kind if you enter this plea? And do you understand that you'd be giving up your trial rights, which are starting on the bottom of page 1 and going on to page 2 of the plea agreement that you've read, understood, and now signed? Okay. Do you understand that you're waiving any potential defenses that you may have? Do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? Do you understand the terms of this agreement designate you as a sexual predator? And that you'll deal with those restrictions and your sex offender probation for the rest of your life? All right. Do you have any questions about that? All right, and what is your plea to the 2 counts of lewd and lascivious molestation on a victim under 12, violation of 800.045B? I'll accept your no contest plea as freely, voluntarily, and knowingly given. In each count, it's going to be 50 years in the Department of Corrections with credit for all time served, followed by a lifetime of probation. You're to have a GPS monitor connected before you're released. No contact with any minors. You'll be designated as a sexual predator. $817 in court costs, $50 application fee, $100 cost of defense. I said lifetime probation just to make sure that's lifetime of sex offender probation. And that will be the same for count 2, and they'll run concurrent. Anything that I've missed?
No, and just so the record's clear, if this becomes an issue in the future, the reason why I wrote lifetime sex offender probation on count 2 was because I forgot to write it on count 1 that it was sex offender probation.
Oh, that's fine.
So I just wanted the document to say it somewhere.
All right. Mr. Berry?
GPS at $1 a day, and
G-
it should be attached prior to release.
I said the second part, but GPS at $1 per day, it's to be attached before he is released.
And the supervision fees waived based on the appointment of the public defender.
Yes. Cost of supervision will be waived due to the fact that he's represented by RCC and has been declared to be indigent.
That is, I think the court said it, credit for time served.
Credit for time served.
Okay, just want to make sure.
All right. Does probation need to meet with him?
I just need to get him to sign something.
Okay. All right, so he's meeting with probation, then I need your fingerprints, Mr. Knopfinger, and then you have 30 days to appeal the judgment and sentence of the court.
I think the only other individual I had was Michelle Kahn. I did look, we filed a waiver for Ms. Kahn.
You did?
Yeah, so if we could continue her to the June 24th docket. She is in Kentucky, and I have advised her, like, if there's going to be a plea or something, you're going to have to, the transfer process, so we've started those discussions, so.
All right. Ms. Khan will go to June 24th, I'm sorry, June 22nd at 9 o'clock for pretrial conference. Yes, sir. All right. Mr. Maddox, do you have more cases?
Yes, Your Honor, I have 4 that are ready for pleas.
All right.
Mr. Cobb? Can I approach, Your Honor?
Yes, sir. All right, Mr. Cobb, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Mr. Cobb, can you state your full name and date of birth, please? All right, and Mr. Cobb, you're here in 25 CF 2101, charge of failure to register, excuse me, which is a third-degree felony punishable by up to 5 years in state prison. Do you understand that? I'm going to give him a plea and sentencing agreement that would have you plead no contest to that charge, be adjudicated guilty, so it's a felony conviction, 6 months of community control, a GPS monitor at $1 per day during that community control. Court costs would be, oh, I'm sorry, $666. You did it to me again. You wrote nothing next to
I
court
got
costs
from
and you
the-
hand wrote it
I got
in.
from the clerk. I was trying to. get them.
$666 court costs, $150 cost of defense, waive cost of supervision. Is that your understanding of the agreement, Mr. Cobb?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
Okay, and this is a downward departure, is that right?
Yes.
All right.
Based on an umpires plea bargain.
Okay, he scores 40 months. Anything else you want to state regarding why the plea was offered?
It was his first,
So the situation was, Your Honor, that he had registered some of there was a mix-up essentially in the email that was used to register the Instagram handle. So there were some efforts to register it. He spoke with the officer on body camera who informed him of the error, and that same day he went and fixed it.
Okay. All right, Mr. Cobb, is this what you want to do today?
Yes, sir.
Have you had enough time to go over this agreement with your lawyer? Did you understand and sign the agreement? Are you satisfied with your lawyer's representation in this case? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way? Has anyone promised you anything in return for your plea? You understand by entering a plea that there won't be a trial of any kind. You understand you're waiving your trial rights, which are listed on page 2 of the agreement you signed. You understand you're waiving all potential defenses that you may have. Do you understand that if you're not a U.S. citizen, you could be deported or excluded from the country based on this? All right, and what is your plea to the failure to register? I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, 6 months community control GPS monitor during that community control at $1 per day, $666 court costs, $150 cost of defense, waive cost of supervision. This is a downward departure based on the state announcing it as an uncoerced legitimate plea bargain, where he scored 40.725 months. I need you to meet with probation, who's sitting there behind you. I also need your fingerprints. Let's do the fingerprints first, then probation, and then you have 30 days to appeal the judgment and sentence of the court. All right, thank you, Mr. Cobb. Withdraw the capias that was entered earlier.
Oh, thank you, Your Honor. We again apologize for his tardiness. Sure, that's fine. Your Honor, this is Mr. Brand before the court in 25 CF 848. It was set for plea or trial today. We have reached a resolution in the matter. If I may approach, Your Honor.
Yes. All right, that is 20 counts, all second-degree felonies, but it says maximum incarceration is life.
According to the score sheet, he would have been eligible for a life sentence. That's why it's on there that way. He did score over the 363 points.
Mr. Brand, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Christopher Douglas Brand Jr., September 25th, 97.
All right, Mr. Brand, you're here in 25 CF 848 with 20 counts of possession of child pornography, second-degree felony, which individually, those charges are 15-year maximums, but because of your score sheet, that you were looking at a potential life sentence. Do you understand that? Okay. I've got a plea and sentencing agreement here that would have you plead to the unenhanced possession of child pornography, so those are third-degree felonies under 827.071, paragraph 5. You'd be adjudicated guilty, be designated as a sexual offender, 817 court costs, $150 cost of defense. In counts 1 through 3, it'd be 5 years Department of Corrections for each count consecutive with credit for all time served, so that's 15 years in DOC, correct?
Yes, Your Honor.
You understand that, Mr. Brand?
Yes, sir.
And then you also have 11 counts. That's 4 through 14. That would be 5 years of sex offender probation concurrent with each count. No contact with any minors, directly or indirectly, a GPS monitor, $1 per day during the course of your probation. You must report your probationary status to your employer, meaning that you must report that you're on probation and the charges that you're on probation for. No visitation to places where minors regularly congregate. Waive cost of supervision. Count 15 will be 5 years of sex offender probation consecutive to the probation in counts 4 through 14 with the same terms. Still waiving cost of supervision. Count 16 through 20 will be dismissed by the state. So basically it's 15 years Department of Corrections followed by 10 years of sex offender probation.
Yes, Your Honor.
Everyone's on the same page on that.
Yes, and I've gone over this plea agreement a couple of times now with Mr. Brand. I went over the plea agreement line by line with him in terms of everything that's in there. I've given him an opportunity to ask any questions that he has because we did move it around a little bit to accomplish this sentence from yesterday to today. Mr. Brand, do you have any other questions for me? All right.
But it's still a downward departure.
Slightly, yes.
So it would be 195 months, he's doing 180 months. All right. And the reason for the downward departure?
Coerced plea bargain and the need for treatment.
All right. All right, Mr. Brand, did you have enough time to go over this agreement with your lawyer? Did you understand and sign the agreement? Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I just read to you? Do you understand by entering a plea, there won't be a trial of any kind? Do you understand that you're giving up your trial rights, which are on page 2 of the agreement that you signed?
Sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right, Mr. Brand, what is your what is your plea to the 15 counts of third-degree felony possession of child pornography? I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty. Sex offender designation, 817 court costs, 150 cost of defense, and counts 1 through 3, it's 5 years Department of Corrections for each count consecutive with credit for all time served. Counts 4 through 14 will be 5 years of sex offender probation, concurrent with each count, no contact with any minors, directly or indirectly, a GPS monitor at $1 per day during the duration of your probation. You must report your probationary status to any employer, meaning that you're to report that you're on probation and that the charges you're on probation for. No visitation to places where minors regularly congregate, waive cost of supervision. That's again sex offender probation. Count 15 will be 5 years of sex offender probation consecutive to the probation with counts 4 through 14 with the same terms, also waiving cost of supervision. Does the state have an announcement on counts 16 through 20?
State dismisses those counts in exchange for a plea to the other counts.
Okay. And I'm going to adjudicate you guilty. I do need you to speak with probation once they're available, Mr. Brand. I also need your fingerprints. And you have 30 days to appeal the judgment and sentence of the court. This was a downward departure based on an uncoerced plea bargain as well as the need for treatment according to the state.
Yes, Your Honor.
All right, thank you, Mr. Brand.
GPS to be attached prior to release.
Yes, GPS attached before release.
Okay.
May I approach, Your Honor?
Yes. county court misdemeanors on here too?
Yes, Your Honor.
All right, Mr. Day, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, make sure you speak up loudly into that microphone. Can you state your full name and date of birth?
Jonathan Anthony Day, 3/24/1991.
All right, and Mr. Day, you're here in 26 CF 607, which is a possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison. You have 2 violations of probation, that being 26 CF 4, where your maximum is 6 years, 25 CF 2351, your maximum is 5 years. They're also attaching 2 misdemeanor pleas, 26 MM 836. It's petty theft, punishable by up to 60 days county jail. Count 2 is resisting the recovery of property, first-degree misdemeanor, punishable by up to a year in jail. And 26 MM 837, another petty theft, punishable by up to a year in jail. Do you understand your current charges?
Yes, sir.
All right, the plea and sentencing agreement I've been handed calls for you to plead to the 3 felonies, be 11 months, 29 days county jail, concurrent with credit for all time served, $615 court costs. In the 607 case, $200 in VOP fees, $350 cost of defense, adjudication of guilt. Those costs will go to judgment. That's when you admit your violation of probation. It'll be revoked and terminated. All probation costs or monetary will go to judgment as well. In the 2 misdemeanor counts, it's credit for time served, adjudication of guilt, $270 of court costs in each case, $50 cost of defense in each case. All of those costs go to judgment as well. Is that your understanding of the agreement?
Yes, Your Honor.
Is that the state's agreement?
Yes, Your Honor.
All right, Mr. Dade, have you had enough time to go over this agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign that agreement?
Yes, Your Honor.
Are you satisfied with your attorney's representation and advice in the case?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
You understand that on the VOP cases, if you admit your violation of probation, there won't be a hearing where the state would have to prove how you violated? You don't understand that?
No, I do understand, sorry.
Okay. You understand there won't be a VOP hearing going forward? Okay. And do you understand that by entering a plea in the 26 CF 607 and the 2 MM cases, that there won't be a trial on any of those as well? And you understand you're giving up your trial rights, which are listed on page 2 of the agreement you signed? And do you understand that you're waiving all potential defenses in all of these cases? And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right. All right, and what is your plea to the 2 violations of probation? Are you admitting or denying those?
Admitting.
I'll accept your admissions to the violations of probation as freely, voluntarily, knowingly given. As to the possession of controlled substance, petty theft, resisting recovery of property, and another petty theft, what is your plea?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given on those cases. In the 3 felony cases, it's all counts 11 months, 29 days, Okaloosa County Jail, concurrent with credit for all time served, $615 court costs on the 607 case, $100 VOP fee on each of the VOPs for a total of $250 application fee plus $100 cost of defense per case on the 3 felonies, adjudication of guilt, revoke and terminate your probation. All costs and probation costs go to judgment. In the 2 misdemeanors, 26 MM 836 and 837, credit for time served, adjudication of guilt, $270 court costs in each case, $50 cost of defense each case. Those costs will also go to judgment. Mr. Day, I need your fingerprints before you leave here, and you have 30 days to appeal the judgment and sentence of the court. This is a guideline, well, it is a departure.
Slight departure, yes, Your Honor.
Yes, Judge, based on a legitimate negotiation.
Okay. I mean, wasn't much of a departure. It's from 13 months to 12, basically, but I do have to mark that. All right. You have 30 days to appeal. Mr. Day, make sure you get your fingerprints on the way out. All right. Anyone else? Fiducia.
Your Honor, this is Mr. Fiducia before the court in 26 CF 202. We do have a resolution. State it for me. Approach.
All right, Mr. Fiducia, raise your right hand, please. Do you understand, or I'm sorry, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
David Anthony Fiducia, September 6, 1968.
All right, Mr. Fiducia, you're here in 26 CF 202, where you're charged with burglary, third-degree felony, grand theft, third-degree felony, criminal mischief, third-degree felony, and violation of your driver's license restriction by an as a habitual traffic offender, also a third-degree felony. So each of those counts are punishable by up to 5 years in the state prison. Do you understand that? I've been handed a plea and sentencing agreement that would have you plead to a lesser included count 2 of petty theft, Florida statute 812.014, paragraph 2, subparagraph F. Also, misdemeanor driver license suspended, 322.342B1. It'd be 11 months, 29 days of probation. Wasn't he recently on probation?
Mr. Fiducia?
Okay.
I don't know the answer to that offhand, Your Honor. Is the state aware of him having recently?
I'm just wondering if it's the, never mind. Mr. Berry?
His last probation was revoked and he did a jail sentence.
Okay.
So he wasn't currently on probation with this.
I understand, it's just, in looking up his name, there's a lot of cases here, Mr. Fiducia, and I'm not going to reject the offer of the probation, but just wondering if this is something you're going to be able to get through.
Well, I promise.
All right. I hope so, Mr. Fiducia. I'd like to not see you here for a while.
Yes, sir.
All right, $300 in court costs, $100 cost of defense, adjudication of guilt, reserve restitution for 90 days, waive cost of supervision, and then counts 1 and 4 would be dismissed. Is that the agreement you've made?
Yes, sir.
Is that the state's agreement?
Yes, Your Honor, and the state complied with Marcy's law, and this is, part of the reason for this request is based off of speaking with both victims in this case, Your Honor.
All right. All right, Mr. Fiducia, have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are on page 2 of the agreement that you signed?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the lesser included petty theft and drivewall license suspended misdemeanors?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. State have an announcement on counts 1 and 4.
State will no pros counts 1 and 4, Your Honor.
All right. Be adjudication of guilt, 11 months, 29 days probation, $300 court costs, $100 cost of defense, adjudication of guilt, reserve on restitution for a period of 90 days, waive cost of supervision. All right, and you just speak to probation behind you, Mr. Fiducia, and you have 30 days to appeal.
Each count
Each count is concurrent.
Thank you, Your Honor.
Is that it?
That should be it.
Is that it?
Does anyone else have anything down for me? I don't think so. Oh, didn't they send him back to the jail though? Yeah, when we have him for May 7th, correct?
What happened with Ewing with Mr. Klein's?
Your Honor, that was the one where he had the plea but forgot to have him stay for the
Okay,
fingerprints.
so we're going to do that later this week, right?
Yes, Your Honor.
Or do we changed it? Okay. All right. So let me just make sure I've got all the trials the same as y'all have currently set. We've got Frasier,